Good afternoon, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. We're here in dockets number 2021-143E and 2021-144E. Before we get started, let's take a brief moment of silence. All right. Present in the hearing room, we have Commissioners J. Williams, C. Williams, Powers, Belzer, Thomas. Joining us virtually, we have Commissioners Irvin and Casson. Before we get started with our witnesses, are there any preliminary matters we need to take up?
Mr. Chairman, this is Commissioner Irvin.
Commissioner Irvin, you have the floor, sir.
Thank you, Mr. Chair. I had a chance to reflect on yesterday afternoon's exchange, and I was asked by Counsel for ORS after Commissioner questioning whether I thought I could continue to be fair and impartial, or had I made up my mind. I believe the record will reflect that I had not made up my mind, and I was going to listen carefully to the testimony and evidence, and that's what I intended to do. But I also want to protect the integrity of the process. I respect this process. I consider it a search for the truth, and I don't want any party to have any doubt after the hearing's over and after the orders have been filed and all appeals have been heard and disposed of. I don't want anyone to have any doubt that they got a fair and impartial hearing. And while the Counsel for ORS did not ask me to recuse, I want to further ensure the process is fair to all concerned. And I think it best that I step aside and recuse myself on my own motion. And to the extent that we had an exchange that may have offended someone, I'm deeply sorry and I apologize for that. I was trying to develop a record that the commission could rely on to find the truth and render a fair and just decision. And so, Mr. Chairman, I'm going to recuse myself from further participation in these two dockets. And for that reason, I will not be participating in the deliberations, nor will I be participating in the order writing or the final order or any post-trial motions. I'm recusing myself for the reasons stated. And I appreciate the work that the parties are doing. I know that it has been a hotly contested case, but I know that you were trying to find a result that's in the best interest of everyone. And I want to encourage you in the sense that, you know, I respect your role as advocates, and I certainly expect for you to stand up for your clients. And Mr. Chairman, I'm going to sign off having recused. Thank you, sir.
Thank you, Commissioner Irvin. Commissioner Irvin is signing off based on his decision to recuse himself from this matter, meaning he will no longer listen to the hearing or participate in deliberations or order writing. All right. Anything else before we start with Mr. Ori? Nothing? ORS, please call your next witness.
Thank you, Mr. Chairman. This is Andrew Bateman with ORS. We call to the stand Mr. Brian Ori.
All right, Mr. Ori, if you would pause to be sworn in by the court reporter.
Mr. Horry, if you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Ori, please state your full name and occupation.
My name is Brian Horry. I'm a senior partner at Energy and Environmental Economics, also known as E3.
Thank you, Mr. Ori. Would you please summarize your education and relevant experience?
Yes. I graduated from Stanford University with a bachelor's and a master's degree in civil engineering, energy, and environmental planning. My coursework focused on renewable and building energy systems and was supplemented by work for the City of Palo Alto utility as a solar energy analyst and coordinator. After graduating from Stanford University, I worked for Pacific Gas and Electric Company, first in the rates department, and then in PG&E's research and development department. While in the rates department, I was involved in the development of marginal costs and was PG&E's expert witness on the use of marginal costs for determining class revenues and rate designs. That work included the pioneering of the estimation and application of marginal transmission and distribution capacity costs that recognize the variation in the timing of T&D peaks across the utility system. While at PG&E, I was also co-author for the EPRI study, Targeting DSM for Transmission and Distribution Benefits, a case study of PG&E's Delta District. That study started the field of local integrated resource planning in the industry. I also was a contributor to the DOE-funded PG&E R&D study, The Value of Photovoltaics in the Distribution System, the Kerman Grid Support Project. These studies led to my moving to PG&E's R&D department to work on the PG&E Distributed Utility Evaluation Project that further investigated the potential for local resources such as EE and local generation to cost effectively avoid or defer the need for traditional T&D solutions. I left PG&E in 1993 to help start E3 and continued my work in cost effectiveness evaluation of EE, DSM, and local generation and storage, doing projects for myriad utilities across North America. For more than a decade, E3 has been a lead consultant for the California Public Utilities Commission, and I have personally worked on CPUC projects related to solar customer generator compensation, avoided costs, and cost effectiveness evaluation of EE, DSM, and local generation and storage. In particular, I personally wrote the methods and original code that have been used to evaluate the cost effectiveness of all EE programs for PG&E, SDG&E, and SCE since 2005. Finally, some other projects that are particularly relevant to this proceeding include 1, third-party evaluator for the development of locational avoided costs by the Minnesota Electric Utilities. 2, consultant to the Idaho Legislature Conservation Subcommittee on Demand-Side Management and Conservation. And 3, contributor to the 2006 U.S. DOE and EPA National Action Plan for Energy Efficiency.
Thank you, Mr. Horry. Mr. Chairman, at this time, in accordance with Commission Order number 2021-137-H, I respectfully request that Mr. Horry be recognized as an expert in avoided costs, utility rate making, and DER, DSM, and energy efficiency cost effectiveness evaluations.
Okay, any questions or objections?
No objection from the committees, Mr. Chairman.
Mr. Horry is qualified as an expert in the stated areas.
Thank you, Mr. Chairman. Mr. Horry, are you the same Brian Horry who pre-filed 31 pages of redacted and confidential direct testimony and 6 exhibits, both redacted and confidential, in this case on September 21, 2021?
Yes.
And do you have any changes or corrections to your pre-filed testimony or exhibits?
No, I do not.
And if I asked you the same questions contained in your pre-filed direct testimony today, would your answers remain the same?
Yes, they would.
Thank you, Mr. Horry. Mr. Chairman, ORS asks that the redacted pre-filed direct testimony of Brian Horry be entered into the record of this case as if given orally from the stand, and that Mr. Horry's exhibits 1 through 6 be marked as a composite hearing exhibit and entered into the record as the next hearing exhibit.
Mr. Horry's redacted direct, pre-filed direct exhibits, Mr. Horry's redacted pre-filed direct testimony will be entered into the record as if given orally from the stand, and Mr. Horry's exhibits BKH 1 through 6 will be marked and entered into the record with exhibits 3 and 4 remaining confidential.
Thank you, Mr. Chairman. I think you jumped ahead. I also wanted to confirm that the confidential testimony exhibits were entered into the record under seal.
Okay, and those are 3 and 4, correct?
Mr. Horry, could you confirm, are those exhibits 3 and 4 that contain the confidential information? And I believe your direct testimony also contains a bit of confidential information, if I'm not mistaken.
Yes, my direct testimony definitely contains confidential information, and just looking at those exhibits. Exhibit 4 is confidential. And Exhibit 3 is confidential also.
All right. So let's start over. Mr. Horry's pre-filed direct testimony will be entered into the record as given orally from the stand with the confidential portions remaining under seal. Mr. Horry's exhibits, BKH 1 through 6, will be marked as a composite exhibit and entered in the record as hearing exhibit 8 with exhibits 3 and 4 remaining confidential and under seal.
Thank you, Mr. Chairman. And are you the same Brian Horry who pre-filed 33 pages of rebuttal testimony in this case, or in these dockets on October 15th, 2021?
Yes, I am.
Do you have any changes or corrections to your pre-filed rebuttal testimony?
No, I do not.
And if I ask you the same questions today as those contained in your pre-filed rebuttal testimony, would your answers remain the same?
Yes, they would.
Mr. Chairman, at this time, ORS asks that Mr. Horry's pre-filed rebuttal testimony be read into the record as if given orally from the stand.
Mr. Horry's pre-filed rebuttal testimony will be read from the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Horry, did you prepare a summary of your direct and rebuttal testimonies?
Yes, I did.
Would you please present your summary to the commission?
Yes. Good afternoon, Mr. Chairman and members of the commission. It is an honor to sit virtually before you today and present my testimony on this issue of solar PV as an EE program. In my testimony, I show that there are many reasons why this commission should reject DEC and DEP's attempt to get approval of EE incentives for solar PV. And I would look forward to discussing any of those reasons with the commission, but at the end of the day, there are 3 fundamental points. 1, solar PV is a generation resource, not an EE or DSM resource. No other jurisdictions provide EE incentives for solar PV, and no amount of out-of-context wordsmithing by the company will change the fact that solar PV does not match how the industry has defined EE or DSM. Solar PV as EE, or I should say second point, is that solar PV as EE fails the TRC test, which is the only test that considers the impact on all of Duke's customers, that is, the participants and the non-participants. The commission has already recognized the value in considering multiple cost test perspectives, so it would be inappropriate to limit the review of solar PV as EE to just the UCT perspective. And 3, solar PV as EE also fails the UCT benefit to cost test. The benefits under the UCT test exclude the benefits attributable to participants that would have installed the solar PV even if the EE incentive program did not exist. These participants are known as free riders. Duke's own data shows that about 79% of participants would likely be free riders, as opposed to Duke's assumption that only 10% of participants would be free riders. Once the free rider assumption is corrected to 79%, we see that the small remaining fraction of benefits makes the program fail the cost effectiveness test. I have strong confidence in my free ridership calculations, which are based on the company provided data, and would look forward to discussing these with the commission. Moving on to my rebuttal testimony, in Duke's rebuttal, the company's attempt to bolster their justification for classifying solar PV as EE argue that only the UCT should be considered for evaluating the proposed program and provide numerous unsupported assertions of how the cost effectiveness of the solar PV could be higher than what ORS or Duke has presented. My 33 pages of rebuttal testimony show that the company assertions are incorrect and or unsupported, and do not change my recommendation that Duke's proposed solar PV as EE program be rejected. To do otherwise is very simply not in the best interest of Duke, South Carolina's customers who will bear these costs. This concludes my summary.
Thank you, Mr. Horry. Mr. Chairman, Mr. Horry is available for questions from opposing counsel and the commissioners. Thank you.
All right, thank you, sir. Self-described clean energy interveners.
Thank you, Mr. Chairman. This is Kate Mixon. Mr. Horry, I just have a few questions for you. First, on page 7 of your direct testimony, you state that these programs may benefit members of clean energy advocates through additional incentives for them or their customers. By clean energy advocates, do you mean, say, CCL, Upstate Forever, and Vote Solar?
I'm referring to the signatories to the MOU.
Okay, thank you for clarifying. Are you implying in your testimony that there's some improper reason that these organizations that explicitly support clean energy as part of their missions would support these incentives in this program?
I'm not saying whether it's proper or improper. I'm just saying that it is going to benefit their interests. And I think it needs to be clear that for many of the signatories, there are, financial benefits. For others, there may be more mission benefits, but there are going to be benefits for those organizations.
Okay, Mr. Horry, are you aware that SACE, CCL, Upstate Forever, and Vote Solar have no solar company, utility, or energy company members at all?
Oh, well, that's why I said it may be more mission benefits. They're interested in promoting solar, and this would certainly be additional promotion of solar. But certainly there are some signatories who do have financial interests.
Okay, thank you. Thank you, Mr. Horry. Mr. Horry, are you familiar with nonprofit governance or fundraising?
To some extent.
Okay, well then are you aware that nonprofits explicitly may not operate for the private financial benefit of their members?
That sounds right, and I don't think I've implied that there's necessarily financial benefit for the nonprofit signatories, but there are private company signatories to the MOU.
Okay, but as to the nonprofit organizations, you agree there are no financial, that they are not intervening here because it would financially benefit their members, correct?
I actually don't know one way or the other. I'll take your word, subject to check, that that's the way those particular groups operate.
Okay, thank you, Mr. Horry. Mr. Horry, you would agree, would you not, that solar is a renewable energy technology?
Yes, I would.
Okay, and that conclusion, like you say that based on your own, engineering or technical expertise?
Yes.
Okay, but you're not an attorney, is that correct?
Certainly, I am not an attorney, but I've been, in the energy industry for over 30 years and actually studied solar energy, during my time at Stanford University. So I certainly understand how the technology works, and certainly understand the plain language interpretation and the industry understanding of what a renewable technology is.
Okay, thank you. And you don't. So again, you don't have any legal training or background, correct?
Well, I do a lot of regulatory work. I do a lot of things like tariff development, a lot of work on contract structures, terms and conditions. So I wouldn't say I'm totally sort of out of the legal realm, but certainly I do not have a legal degree. I do not, hold bar membership in any state. I've not gone to law school.
Okay, thank you, Mr. Horry. So on page 10 of your direct testimony, you testify that even California doesn't classify solar as energy efficiency. Is that correct?
That's correct.
Okay. Does California have a statute that defines demand side activities to include renewable energy technologies?
No, I don't believe they do have such a statute.
Okay. Thank you, Mr. Horry. Those are all the questions that I have for you.
Solar Energy Industries Association.
Thank you, Mr. Chairman. Mr. Horry, my name is Charlie Terraney. I represent the Solar Energy Industries Association. I don't believe we've had the opportunity to meet yet, so I wanted to introduce myself at the beginning.
Nice to meet you.
It's nice to meet you too. I know you've made several appearances at the commission, and we finally have the chance to encounter one another. Mr. Horry, in your direct testimony on page 5, you refer, and I believe elsewhere as well, you refer to the Energy Information Administration. Is it an EIA definition of energy efficiency?
Yes, that's correct.
And that definition says that energy efficiency is using technology that requires less energy to perform the same function. That's the definition you've relied on in your testimony, correct?
That's certainly the definition I cite. Certainly my testimony is based not solely on this definition, but also just my experience in the industry.
You don't disagree with that definition?
No, I think that definition is a good definition.
Okay.
Mr. Terraney, if you could, sir, please speak a little louder or get closer to your microphone.
I'll try, Mr. Chairman. Mr. Horry, on page 9 of your direct testimony, you acknowledge the fact that Duke Energy, or one of the Duke companies, has previously offered solar hot water heaters as part of an energy efficiency offering, correct?
Correct.
And you make the point that solar hot water heaters operate differently from solar voltaic systems. Would you agree with that?
Yes, that's correct.
As a matter of fact, what you said was a solar DHW, that would be domestic hot water system, uses heat from the sun to preheat the water for the house. In doing so, it does not generate electricity, but actually increases the energy efficiency of the home's natural gas or electric hot water heater by reducing the amount of natural gas or electricity needed to bring the water up to the household's chosen hot water temperature. Did I cite your testimony correctly?
Yes, that sounds correct. In that way, it's the same as like a solar hot water heater blanket. That used to be a common energy efficiency measure. It just reduces the amount of energy that's needed to bring that water up to the desired temperature for the household.
That's right. It uses the sun's energy to heat the water. Would you agree?
That's the source, yes.
And that source, that energy is heat. It's using hot sun to heat water. Makes sense?
That's correct.
And heat can be measured in BTUs, correct?
Yes.
And the EIA would recognize, and most people would recognize, I would imagine, a BTU as a measurement of energy, correct?
Yes, but I think we need to be careful of that. The BTU that we're concerned about are the BTU being used to actually heat the hot water. What source BTU may be impacting or striking the solar hot water panel, that's not really relevant. What's relevant is what's happening at the hot water heating device and how much energy that device needs. And the fact that that device can operate and deliver the same sort of functionality to the household by burning, less gas, basically using less, gas BTU, or using less electricity and converting that into BTU. That's where the efficiency is.
Yeah, I think my question was much simpler, which is that solar heat is energy. You wouldn't disagree with that, would you?
No, I wouldn't.
Okay. So what you just said, if I understand you correctly, is that a solar water heater replaces electricity. I think that's what you were just explaining with solar generated energy, right?
It does that, and in doing that, it makes the hot water heater system more efficient because now the hot water system doesn't need to expand as many BTU to bring that hot water up to temp.
Yeah, I'm not disputing that at all. And a solar PV panel also generates energy, correct?
Yes, that's what it does.
It generates electricity through the solar PV system, correct?
That's right. The solar PV is a generator, so that's what it does. It generates electricity.
So both of these systems, solar PV panels and solar hot water heaters, have something in common. They are replacing energy that hot water heater or that home would otherwise use.
Well, see, I think here's where I draw the distinction. The hot water heater system certainly is reducing the amount of energy that needs to be used to create the hot water. The solar PV panel, on the other hand, isn't actually changing any of the household usage. It's changing the purchases of electricity that the homeowner has to make from the utility, but it's not impacting the amount of energy that house is actually using.
Well,
It's changing the source, but it's not changing the amount of energy.
Well, I don't know. If a solar hot water heater, does that mean the house is using less water because they have a solar hot water heater?
No, but the solar hot water heater, that whole system means that that household is actually using less energy from the utility, from natural gas or electricity to create the hot water that it needs.
Well, I think we agree on this. The solar hot water heater means the household is using less energy from the utility, and just in the same way, the solar PV system means the household may at least be using less energy from the utility, all things being equal.
Yeah, certainly they're both using less from the utility, but the solar hot water heating is also using less at that device.
Well, or is it using less, or is it just replacing it with BTUs?
No, it's using less energy at that device.
Less electricity, right?
Mr. Chairman,
Sorry, can you re-ask that question?
I'm sorry. I'm sorry, Mr. Trini. This is Andrew Bateman with ORS. Mr. Chairman, I don't mean to interrupt Mr. Trini. I think sometimes when you've got a video feed, and particularly two video feeds, it's easy to miss that maybe there's a bit of a lag. But there have been a couple instances where my witness attempts to answer, and I think probably due to that lag, Mr. Trini has jumped in. I would respectfully request that Mr. Trini just give a few seconds and allow Mr. Ori to appropriately and fully explain his answers.
I would want nothing less, Mr. Bateman. Let's find our steps back now, because we may have lost our place. The hot water heater with a solar array is using BTUs to heat water. I think you agreed with me on that.
Yes, that's correct.
Okay. And the solar PV panel is generating kilowatts or energy, kilowatt hours, I suppose, to supplement the home's electricity. We agree with that.
Well, to replace purchases from the utility. Yes.
Exactly. And Mr. Bateman, before you jump in, I didn't mean to step over. Both of these systems, in fact, are replacing purchases from the utility. One is doing it through the solar array that generates kilowatt hours, and the other is doing it by generating BTUs. But the thing they have in common is they're both replacing those purchases from the grid. Do you agree?
I agree that that they're both, once you get up to the grid level, that they're the same. But I'm saying that that's not the point to look at. What you look at is, are devices actually more efficient within the household? With the solar hot water heater, it certainly is. And with the solar PV generator, it certainly isn't. There is no improvement in efficiency, no improvement in the way that electricity is used within that household just by installing a generator on a customer's rooftop.
No, the improvement's at the grid level, right?
Improvement is at the grid level. I would agree with that.
Thank you, Mr. Horry.
Duke Energy.
Yes, Vice Chairman, thank you. Let me just, if you'll give me just 1 second.
Mr. Wellborn, why don't we stand at ease for a few minutes?
Yes, Vice Chairman.
Just everybody hang loose a second.
All right. We're back on the record. Attorney Wilburn, are you ready to proceed?
Yes, Mr. Chairman.
All right, go right ahead.
Thank you, sir. Good morning in California, Mr. Horry, and good afternoon in South Carolina. Can you hear me okay?
I can. Thank
Good.
you.
Good, thank you. Do you recall approximately when you were retained by ORS to consult in this docket?
Not offhand. I know we had sort of brief mention of this during another case. It was one of the avoided cost proceedings. And I know I certainly did not start diving in deep into this case until that proceeding was finished. But I don't recall the exact date.
You can't give a month or a year in which you were retained by ORS to support their efforts in this docket.
Well, if you'd like me to take, 5 minutes and go through my emails,
That'll be fine.
I could track that down for you. Okay.
I mean, was it fall 2020? Was it August 2021? Was it spring? I mean, ballpark, you can't recall when you were retained by ORS to support their efforts in this docket?
I would say it was probably within a couple of months of ORS's direct testimony being filed, if that gets close enough for your purposes.
Okay, this isn't a critical point. I don't want to be here all day, but
Sure.
would you hazard a guess to say August 2021? It's not a vital point. I won't slow us down on this, but
Okay. Yeah, I just like to try to actually, provide accurate information when asked the question. I don't like to just sort of guess, but if you can remind me of the file, actually, let me just check the filing date of my testimony. September, so yeah, I think it would have been sometime in August.
August 2021. Thank you, sir. I'm sorry that was belabored. And you heard testimony yesterday. Have you been attending the hearings and watching the hearings since the start?
Yes, I have.
So did you hear testimony yesterday that the programs were discussed with the EEDSM Collaborative in November of 2020?
I did hear those discussions.
And then two, that it was discussed again in the January 2021 EEDSM Collaborative meetings at which ORS attended. Is that right?
Well, I certainly heard that was conveyed in the hearings yesterday.
And you yourself actually provided testimony in the Solar Choice docket in February 2021 that preliminarily addressed this program. Do you recall that?
Yeah, I certainly raised a concern that the MOU that has initially been shared by Duke discussed some kind of additional incentive program. And I think that the basis was actually laid out in the MOU, which another party finally filed in that docket. But, sort of I had the information that there was plans to, put forward a program, but my focus in that proceeding was not on that program, since that was something that would come later. My focus really was on the tariff design itself.
Yes, sir. Understandable. Would you say that your role in a proceeding, whether this one or another one, is generally an impartial and objective one, or does it tend towards advocacy?
That's kind of a funny question because, I certainly look to sort of argue what I believe in and also support my client. And I think this commission is well aware that, in the past, I've been asked questions about not just what I'm in a proceeding to testify on behalf of my client, but what I would testify if I were, for example, a consultant to the commission. And so I have presented that view as well. I've always presented what I believe, and to the extent that there is any constraint or any, well, no, constraint's the right word, but extent there's any focus on what I'm conveying. I make that completely clear in my testimony.
So let me rewind just a minute. My question was, in general, do you view yourself as an impartial or objective evaluator, or do you see yourself as an advocate?
Okay, if you want to do sort of the more black and white, certainly the impartial side. I'm an independent consultant. I have, a business that's built on, basically reputation. And so I need to be presenting, what I believe in.
And I read through your testimony filed in this case, direct and surrebuttal a couple times, and you push back on the program being classified as energy efficiency or DSM. You push back on the cost effectiveness test. Is there anything in your testimony filed in this proceeding that's positive or even neutral about the programs? Anything, any one thing?
Well, I don't think it's actually the role of an intervener or another party to necessarily sort of point out any agreements on things. I think it's more valuable to the commission to hear where, I see there are problems. There's certainly, places where I accepted Duke's numbers. And so I suppose you could say that that's supporting the analysis they did. I don't make a point of saying, I agree with this particular point, because I don't think that's very useful to the record if there's no conflict over that point. It's really the points of issue that I think are worth the time to bring forward to the attention of the commission.
Mr. Horry, are you aware that one of the tasks in this case is to fairly and objectively evaluate the costs and the benefits to ensure and to assure the public that customers will see savings out of this program? You've just characterized yourself as an objective witness, and on the same token, said that there's nothing in your testimony that was positive about the programs. How do you reconcile those two?
Oh, that's easy. What I did is basically, I put on, figuratively my energy efficiency hat. I sat down, I looked at, okay, let's go through this energy as if it were an energy efficiency program and see if it would, pass muster, pass the cost effectiveness test. Well, first of all, I saw a problem of, well, it really isn't energy efficiency. And that's the first thing that jumped out at me. But I said, okay, I'll point that out to the commission. But then, should the commission decide, well, they may want to do solar incentive program in the future, maybe not call it EE. And so there's still interest in looking at the cost effectiveness. I dove into the cost effectiveness and I looked at, well, let's look first at the TRC test, because that is the predominant test across the industry. I understand in South Carolina, there was the order to say use the UCT for Duke, but the TRC is still important because that order doesn't say ignore all other tests. It just lays out certain conditions for use of the UCT. So when I look at the TRC test, I see, well, these tests or this program doesn't pass muster. It doesn't pass the cost effectiveness from the TRC.
Thank you for that.
May I finish? And then I looked at, okay.
Mr. Chairman, this goes well outside the scope of my limited question.
Mr. Chairman, Mr. Wilburn is entitled to ask the questions, and Mr. Ori is entitled to answer fully the answers to those questions.
Oris is right. I think he's giving you a whole lot more than what you asked for, but I think that's his right to fully answer the questions that you ask.
Okay, so to continue and to give this some context, Mr. Attorney, you asked me sort of how I approached this and why I didn't, provide anything positive. And what I'm laying out is basically the approach I took. And had I found something positive, I would have pointed that out. But it turns out that every time I sort of peeled away a layer of the onion, it just looked worse and worse. So I looked at, is it EE? I found out it wasn't. I said, okay, let's set that aside. Let's look, does it pass TRC? It doesn't. Okay, let's even set that aside. Let's see, does it even pass the UCT? And when I dove into the analysis that Duke did, I saw, well, it really doesn't even pass the UCT. And so given that it failed those three tests that I looked at, or those three checks, there really wasn't much positive to say about the program.
And Mr. Hoare, you've never filed testimony for ORS in an EEDSM proceeding in South Carolina, have you?
No, I have not.
And you've never supported or provided consulting services to ORS in an EEDSM proceeding in South Carolina, have you?
I have not, and I think it's worth pointing out that energy efficiency filings are usually very non-contentious. Energy efficiency is kind of like mom and apple pie. Everyone tends to love energy efficiency. It's usually the same kind of stuff that gets proposed in one jurisdiction, it gets proposed in another jurisdiction, or it's a continuation of programs that have been around, for decades. This is a very unique case. And, I think it's the unique nature of this particular EE filing that sort of merits the need for me to be here as a senior partner at a major consulting firm, talking about energy efficiency.
And you've mentioned in your testimony summary a focus on industry-wide norms, industry-wide is a phrase that you've used a bit. Are you familiar with the South Carolina EEDSM regulatory framework, which is that there is a statute, South Carolina Code annotated 583720, that governs EEDSM programs and cost recovery in South Carolina? Are you familiar with that?
Yes, I am.
And underneath that, Mr. Hoare, there is a set of procedures per the statute that's called the mechanism that further governs cost recovery and program approval by the commission. Are you aware of that?
Yes, I'm aware of that, and I should point out that's why I am particularly concerned about whether solar PV gets classified as EE. Because of that mechanism, there are certain conditions attached to something that is defined as EE, such as net loss revenue recovery and shareholder incentives. And so that's why I feel the commission shouldn't take lightly the issue of whether solar PV should be considered as EE, because through that classification, there are all these other conditions. There's all this baggage that's going to come along with that classification. And so I think we need to be aware of that when we consider whether solar PV should be classified as EE and therefore be eligible for all of those incentives and net loss revenue recovery.
But you understand, don't you, that the South Carolina EEDSM statute, again, South Carolina Code Section 583720, specifically refers to energy supply in its definition of demand-side programs. Are you aware of that?
Let's see. If we...
I mean, subject to check.
Yeah, no, I have seen that term in there, but one of the challenges is, understanding what the legislative intent of that statement is, because, I know we're involved in a lot of regulation at state levels. And a lot of times what comes out of the legislature, could be, sort of poorly worded. It could be meant for one thing and then gets, interpreted for another thing. Or it could be that the, legislature may just not have been made aware of all the potential, future impacts and nuances. So, I understand that language is there, but I also believe it's the, commission's right or obligation to evaluate whether solar PV is energy efficiency and should therefore, be eligible for those net loss revenue recoveries, or if other legislature may ban such net loss revenue recovery.
Thank you. Mr. Hoare, do you have Morgan Cross Exhibit 1 available to you? Do you have that?
The Cross Exhibit 1. I believe so. If you can point me to a page and then say what's on the page, I can confirm I have the right document.
Yes, sir. Well, on the first page, just to make sure we're on the literally on the same page, it should say Morgan Cross Exhibit 1, number 1, and this is the order approving the revised DSM EE mechanism. This one in particular is for Duke Carolinas. I believe Duke Progress is in the same exhibit.
Okay, I have that.
Thank you. If you will turn, please, to page 38. It's the Bates number read, page 38 at the top right.
Okay.
The last full paragraph of that page, tell me if I'm reading this sentence correctly. The first sentence says, with the exception of low-income programs or other programs explicitly identified at the time of application for their approval, all programs submitted for approval will have a program level UCT result greater than 1.00. Did I read that correctly?
Yes, you did. And I'm familiar with that. I read that same line in the same order. And, at least what jumped out to me was there was nothing in the order saying the UCT is the only test that the commission may consider in deciding whether or not to approve a program.
Thank you. And in the paragraph above that, and I'll read this to you because it's sort of buried in the middle and I don't want to get crosswise with you, but it says, an EE or DSM measure with a utility cost S UCT result less than 1.0 will not be considered further unless the measure can be bundled into an EE or DSM program to enhance the overall cost effectiveness of the program. Do you see that?
Yes, I see that.
In other words, it looks like, and you tell me if you agree or not, but what the companies can do is package together different elements or different features or requirements into a single program in order to result in a higher cost effectiveness score. Would you agree with that?
Well, when you do bundling, you actually end up with a lower cost effectiveness result just because you're diluting the cost effectiveness of the good program with the bad program. And this is often done in the industry, but it's usually done if you're looking to sort of promote a program that wouldn't pass cost effectiveness of its own, but has some other reason why it needs to be incented. Some other reason why it needs sort of the market assistance, or maybe there is sort of a lost opportunity. A lot of times with new construction programs, at the time of new construction, that's the best time to get a new program in. And if you don't get that energy efficiency in at the time the house is built, then you've lost that opportunity. The homeowner isn't going to retrofit. So they're usually sort of considerations like that go into this bundling. But what's I think needs to be remembered in this particular case is the BYOT piece. That's an already established program. Solar PV, that's an already established resource or alternative in in South Carolina. And so I just don't see the need to bundle those two together in this particular case.
But you're aware, aren't you, Mr. Horry, that what the company has proposed in this case is not just joining BYOT, but it's a 25-year commitment to BYOT, which means that the company would control your thermostat on very cold days for 25 years. Are you aware of that 25-year commitment?
I'm aware of that, but I'm also aware that the company hasn't really exercised the winter BYOT program yet, and so it's unclear how many times the program would be operated, and so it's not clear to me how much of a burden BYOT program might be on customers. I come from again sort of a rate design background as well, and I know a lot of times incentives are offered in order to make customers happy without the expectation that the requirements of the program would ever be exercised. I mean, non-firm programs, curtailable rate programs are a common example of this for industrial customers. Also, I should point out, when I saw the bundling of the solar with the winter BYOT, I didn't really see a synergy there. I didn't see the need to bundle those. It's not like solar plus storage, where you charge the storage from the solar, so there's a clear synergy. Nothing about that solar PV is going to help your winter BYOT program. It's not like you're going to heat the house during the winter day and then hope that the house stays warm so you don't need as much heat on the next cold winter morning. You know, it's just not going to work that way. So yes, Duke has bundled these programs together, but I see no reason other than trying to, you know, maybe make this program seem more palatable to the regulators, that you would do such a combination of these two.
You're getting me a little bit sidetracked. What's the basis for your belief that the companies haven't used winter BYOT?
When I asked for information on the dispatch history for the BYOT program, the information that company sent back indicated only summer dispatches.
And that's because winter BYOT is a new program, right?
Well, I'm not sure how new. I mean, if it hasn't even reached the first summer, then certainly that would be an explanation. But again, there'd be no history for how this program would be operated.
So, but you understand that the companies are winter peaking, don't you?
Yes, I'm certainly aware of that. I've been involved in a lot of Duke avoided cost cases, and I've seen South Carolina basically move from summer peaking to winter peaking. And so I think, you know, the program is probably could be a good program. But again, I don't see the synergy why you need to link the winter BYOT program to an additional solar PV incentive.
Thank you. I'm going to try to move us on. I just emailed out Horry Cross Exhibit number 1, and I'm going to provide a copy to council at this time. I'll pause. I don't know how long it takes for emails to get to California. Also give us a chance to get those distributed in-house. And just to set the stage a little bit, Mr. Horry, this is an excerpt from a recent IRP order that the commission issued. And Mr. Chairman, I'm not going to ask that this be entered into the record as a hearing exhibit, but what I would ask is that the commission take judicial notice of order number 2021-447.
Notice taken.
Thank you, Mr. Chairman. Mr. Horry, do you have that yet?
Yes, I do.
Good. And you see on the first page, this is just an order that the commission issued in late June 2021.
Yes, that's what I see.
Thank you, Mr. Horry. And in the IRP proceeding, if you turn over to what is page 33, I'll give you a minute. The commission acknowledged in that order, didn't it, that the UCT rather than the TRC should be used to model EEDSM forecasts for IRP purposes. Are you aware of that? There's a sentence there that says, having considered the evidence.
Mr. Chairman, I'm sorry, Mr. Wilburn, again, he's entitled to ask the questions, but when he asks a question and doesn't give my witness the opportunity to appropriately respond and then asks a second question, not only does it create confusion for the court reporter, but it muddies up the record. Mr. Chairman, I'd respectfully request that when he asks a question, he lets my witness appropriately and fully respond once again.
I didn't mean to interrupt anything, and I don't think he had spoken yet. I was just trying to help him out a little bit and let him know what I'm looking at.
Yeah, I think everyone's on the same page. I didn't think you were finished asking the question.
Okay.
And I don't think Mr. Horry responded. So I think we're good.
Well, and I appreciate that, Mr. Chairman. May I get a bit of clarification? It's happened a couple of times. When Mr. Wilburn asks one question and then follows it up with a subsequent question, should Mr. Horry answer the first question asked or the subsequent question asked?
How about I withdraw my question, Mr. Chairman? We'll start fresh.
If that's what you want to do.
That's what I want to do.
All right.
Mr. Horry, on page 33 of this IRP order, I'm going to read a sentence to you, and you tell me whether it's right or not. It's the first sentence under the commission conclusions section. It reads, Having considered the evidence, the commission concludes that the UCT is the more appropriate measure of cost effectiveness than TRC for the purpose of developing the EDSM forecast and the IRPs. Do you see that?
I do see that.
Thank you. And in 2 sentences down from that, do you see a sentence that says the UCT has been approved by the commission as the primary cost effectiveness test for Duke? Do you see that sentence?
I do see that. But again, I know that it says primary, not sole.
Yes,
cost
sir.
effectiveness test.
And you said that earlier that you watched the hearing yesterday. So did you hear Mr. Lawyer say that while ORS is looking at the TRC for program approval in this case, that were the program to be approved, that ORS would then review the program based on the UCT? Did you hear him say that?
I don't remember those exact words, but it makes sense that you would look at both tests. And given the way the UCT test is used in things like the shareholder incentives, one would have to look at the UCT test for doing those kinds of calculations.
Thank you. And I would refer you to the next page of that exhibit, page 34. Are you there yet?
I am.
And so in that same order, in the same section, the commission encouraged the companies to, quote, capitalize on EEDSM savings opportunities to reduce energy costs, as well as the risk of rising energy costs for all Duke customers. Do I have that right?
It says that if you'll give me a moment to try to read that in context, one of the things I'm concerned about is, you know, whenever we take snippets out of documents, that there's the potential for it to be taken out of context. I'm not accusing you of doing that in this particular instance, but I do feel that that was done quite often in the testimonies of witness stuff. So I just want to make sure I've got the full context here.
Yes, sir. Take your time.
Okay, I would note that, you know, there was a lot in this section that deals with issues particular to IRP and not so much to EE DSM evaluation. But you know, certainly that last sentence, I mean, that's kind of a mom and apple pie thing, you know, use EEDSM when it's cost effective to help reduce costs. The risk issue is a little different. I think that may be talking about other IRP related issues about long-term planning. But yeah, I mean, that sentence certainly makes sense to me.
And so when you say mom and apple pie type of sentence, you don't mean that the company shouldn't take seriously the commission's encouragement in that sentence, do you?
No, I'm just saying it's common that you would look to EE and DSM to help reduce energy costs. But I also point out that you're looking at energy costs, the total energy costs to customers, you know, the total customer outlay for their energy services. Then you have to consider not just the UCT, but also look at the TRC. My interpretation from reading this section is the UCT versus TRC argument was probably focused around EE potentials. And certainly using a UCT will increase the amount of forecasted energy efficiency potential than using the TRC test. And so that might be, you know, part of the focus on the UCT here.
Again, this is off script for me, but what would happen if you were to resource plan around inflated EEDSM savings and then not have EEDSM programs to back that up?
Well, it's very kind of utility specific on what the needs are for new resources. Certainly, I think I understood your question to be, what if you overestimated the amount of EE you would receive? Then there's the potential to basically be short on resources. But then also point out that, in California, they actually plan for double the achievable energy efficiency. So they actually say, okay, what do we think can actually be achieved? And we're going to set basically a stretch goal. We're going to say, we're going to plan that utilities and third parties are somehow going to achieve twice that amount. So, I think certainly putting a stretch goal into an IRP isn't necessarily going to cause, huge cost impacts, because a lot of jurisdictions sort of do that purposefully. But certainly there's a potential to be, a bit off on what your resource needs are in the future if your energy efficiency forecast is off.
Thank you. And just to pick that back up kind of where we were, there was this line in the order that I referenced, wasn't there, that Duke's encouraged to capitalize on EEDSM savings. Isn't that right? Do you remember that?
Yes, I see that.
So you've been qualified as an expert. I'm going to try out a hypothetical on you. Would you agree that were there to be, and sort of reserving your reservations about this particular program, were there hypothetically to be a cost-effective package of requirements and features that met South Carolina's EEDSM statute and the mechanism, wouldn't it be imprudent for the companies not to offer that program or propose that program?
Mr. Chairman, this is Andrew Bateman. I object. This is an improper hypothetical and requires Mr. Ori to assume facts not established in evidence.
We've got an expert on the stand, Mr. Chairman. He's able to answer hypothetical questions.
Overruled.
I'll repeat it, Mr. Hoare, if you need me to.
Yeah, if you would, please.
Thank you, sir. So we were just talking about that line in the commission's order that said Duke is encouraged to capitalize on EEDSM savings. My hypothetical question to you was, would you agree that, and again, reserving for a moment, putting aside for a moment your reservations about this particular program, were there to be a cost-effective package of requirements and features that met the South Carolina EEDSM statute and mechanism, wouldn't it be imprudent for the companies not to propose that program to the commission?
So the key word in your hypothetical, and I don't know if you meant it to be there or not, was package. And certainly if there are individual programs that are cost effective into individual measures, basically EE devices, et cetera, that are cost effective, then that certainly should be pursued. When you say package, then it's a question of, well, do you have 9 sort of DSM devices in there? I'm sorry, energy efficiency devices in there that are cost effective, and 1 terrible device that isn't cost effective, but if it's bundled in a package, the whole package is cost effective. I don't think that should be promoted unless there is some real strong, sort of well laid out, well defined sort of reason for including that non-cost effective measure in that package.
Yes, sir, but you heard earlier that the mechanism that applies in this state in South Carolina allows the companies to bundle up different measures and programs to boost the cost effectiveness score. Isn't that right?
Yeah, and that's where I was saying, I don't know if there should be a free pass. The utilities should do anything they want, and that there shouldn't be a review allowed of that package to determine whether that package is reasonable, given that it has elements that aren't cost effective. I don't think it'd be in the public interest to just rubber stamp any package just because you can get the total to be cost effective.
This doesn't feel like a rubber stamp to me, Mr. Horry, but anyways. Are you aware that if the commission approves this program and the companies are able to implement the programs in January 2022 as they proposed, it wouldn't hit the EEDSM rider until 2023? Are you aware of that?
I'm not aware of the exact timing, but that sounds reasonable given regulatory lag.
Yes, sir. And because of that, we would have a whole year of data accumulating as a result of the program before any cost recovery occurs. Isn't that correct?
That's correct, but that's only limited to this issue of cost recovery. In that example you gave, basically you've got a year where this program is in place, where customers are signing up for this program, where customers are getting incentives for this program. And then I wonder if, there's been a lot of talk about doing an EM&V and then fixing the problems later. I just think that's a really bad policy because, one, the EM&V study, although you haven't raised it, I'm sure, it's in the commissioner's mind because Duke has raised this as a sort of alternative way to push their program through. But EM&V studies are typically pretty easy because you have historical data on what people use, or you can do sort of direct measuring of device use before and after. For some things like this free rider question is, would someone have done it if it weren't for the incentive? And that's basically surveys is what you're left with. And, there isn't before us an EM&V plan and a survey that we can know with certainty is going to provide us good results. We've seen EM&V studies be, shelved for, a year or more because parties can't agree on how accurate the study is. If you're asking someone if you're asking, let's say, an affluent South Carolinian, if the only reason they installed the solar was because, other South Carolinians provided them $3,500, they may, for behavioral reasons, think, yeah, that's the only reason I did that. But that may just be their behavioral response to, feeling like, well, if I say I would have done it anyway, then I'm basically getting this money that maybe I didn't deserve. And there's that moral conflict that's set up. I'm not saying they would do that intentionally, but there's a lot of work in kind of behavioral studies about how problematic, survey results are. And I'm just concerned that we wouldn't really get a good answer if we went ahead and did this program and then waited a year. Plus, I'm very concerned that if you do this program, if you, in South Carolina, say that solar PV is EE, that the solar industry has a playbook to now take that fact and now expand this in South Carolina and across the nation. Why is it just all electric customers that qualify? I just see them easily pushing this to, well, we should push it to any customer because that's the fair thing to do. Or we should push this in Dominion's service territory. It's already been approved for Duke's service territory. Or we should push it in North Carolina. Or we should tout this in the press, trade press, and go to every legislature and go to every regulator we know and say that South Carolina has had this great win-win-win for everyone, ignoring the non-participants, and further push non-cost-effective solar in those jurisdictions. Now, in some jurisdictions, solar is cost-effective. Solar passes the TRC, and so it may make sense for utilities to offer, incentives for solar. What I'm saying is the commission has to be particularly careful in this case, and that this 1 year sort of let's figure it out later, that's not going to solve the problem, right? That's just going to potentially introduce problems if they let slide solar PV classified as EE when it doesn't deserve to be classified as EE.
Trying to remember where we are, Mr. Horry. So your concern is that that if it gets approved in South Carolina under the South Carolina statute and mechanism, that it'll somehow trickle out to other states across the nation. Is that your issue?
That's, one of my issues. Certainly not my major issue. My major issue is it's just not EE. doesn't pass the TRC, doesn't pass the UCT. But yesterday, Vice Chair Belser asked about a potential Pandora's box. And so I just thought it useful to elaborate on what could happen. If the program is adopted and classified as EE, when there are doubts whether it really should be classified as EE.
But you understand that our task today is to decide whether it fits under the South Carolina EEDSM statute and mechanism. Isn't that our task?
That's the task, but I think if there's a gray area, because I think this whole suggestion to use an EN and V study and just check the cost effectiveness in the future, I think that raises a lot of issues. And I think with that, I think you need to think about what are all the potential outcomes, because that's basically saying it hasn't passed the clear rules we have. And we're basically looking to, sort of, I don't know if you'd say bend the rules, but, sort of be more lenient toward the program. But I think that leniency has to be weighed against what are the potential risks and downfalls of that leniency.
Mr. Hoare, you mentioned, again, the TRC and the value of that in this case. Do you believe that non-energy benefits like water savings and natural gas savings, things like that, should be included in cost effectiveness evaluations?
So something like natural gas savings, a lot of times that depends on the utility. If it's a dual fuel utility, it certainly should be included in cost effectiveness tests. If it's an electricity only utility, then that's sort of a gray area. Water is something we've been struggling with in California for years, whether to include water benefits and cost effectiveness evaluations. Usually we look at that when we look at more of the societal cost test rather than the total resource cost test, where you're looking at sort of an additional range of sort of impacted parties, not just the utilities customers. That's typically when you would see things like a water value go in.
So, but it sounds like there's some gray area. I mean, you had the UCT on the one hand that appears to be relatively crisp, but then when you introduce the TRC and you talk about non-energy benefits, there's this open question as to which non-energy benefits the commission should credit towards the TRC cost effectiveness test. Is that correct?
Well, I think it's more gray area for the societal cost test, which is sort of an expansion of the TRC. And I wouldn't say that's a any kind of gray areas for the TRC. I wouldn't say that's necessarily a downfall of that test. I would just say that test allows more flexibility and allows it to be more expansive when the commission deems it appropriate to be more expansive in that way.
Thank you, Mr. Hoare. I'm going to send out Hoary Cross Exhibit number 2 at this point on this issue. Give me a second. I'll get it emailed over to you. You just let me know when you have that, if you would.
Okay, still waiting.
Mr. Chairman, I don't intend to get this into the record. It's just a demonstrative so that we can discuss the TRC a little bit more.
Okay, I have it now.
Mr. Chairman, this is Andrew Bateman. I honestly do not know. This relates to a relatively recent Dominion docket, and I am not aware if Mr. Hoare was involved in this docket. May I have the chair's permission and request if Mr. Hoare was involved in this docket?
Again, Mr. Chairman, this is just a demonstrative. I don't plan to get this into the record. I just want to discuss some non-energy benefits with Mr. Hoare.
Mr. Chair, to the extent Mr. Ori has no familiarity with this docket or this document and was not involved in this docket, I'd object on hearsay grounds.
All right. Well, he hasn't asked any questions yet, so let's give him an opportunity to do his job. Go ahead.
Thank you, Mr. Chairman. Mr. Horry, we chatted a little bit. You provided some testimony about non-energy benefits. Do you agree or disagree that wastewater savings and avoided and deferred equipment replacement costs should be included in the company's TRC evaluation of this particular program?
No, I wouldn't agree that they should be included. I would agree that some jurisdictions, may include it in their TRC, but currently in South Carolina, my understanding is the avoided costs that are used for cost effectiveness evaluation are energy, generation capacity, T&D capacity, and losses, and also system integration costs for the solar cases.
Thank you. And did Duke include or not include non-energy benefits in its TRC evaluation provided in discovery in this case?
I don't believe they included non-energy benefits.
But if they did, it would have boosted the TRC score. Isn't that correct?
Objection, Mr. Chairman. It calls for speculation.
Again, we have an expert, and he seems to know his way around non-energy benefits and what it does to cost effectiveness scores. So I think it's a fair question, Mr. Chairman.
Overruled.
Could you ask about a specific non-energy benefit? Because there could be, positive benefits and negative benefits of certain activities.
Is it your general experience that non-energy benefits add or take away from a cost effectiveness score?
In general, but not always, they add benefits to the cost effectiveness calculation.
Thank you, Mr. Horry. You assert in your testimony that rooftop solar is not energy efficiency, correct? That's
correct.
And you're aware, again, and I think we've talked through this, but that South Carolina law does not recognize such a narrow view of rooftop solar. Is that correct?
I think you'd have to point me to the specific law and passage that you were referring to.
Yes, sir, that's fine. Do you have Mr. Tim Duff's rebuttal testimony available to you?
I do, but if you're going to point to a specific law, I'd rather you point me to the entire law so I could see the entirety and sort of the sections that are surrounding that.
That's fair, yes, sir. If you'll look at Duff Rebuttal Exhibit 2, sir. I believe that's the law that you're asking for. Just let me know when you have that available.
Yeah, I'm sorry. I'll need to pull that up.
No problem.
Hold on a second. Okay, so 583720?
Yes, sir, that's correct. About the third line down towards the end, there's a sentence that starts, if adopted, these procedures must. Do you see that?
Yes, I do.
And I'll read that sentence and you tell me if I've got it right or not. These procedures must provide incentives and cost recovery for energy suppliers and distributors who invest in energy supply and end-use technologies that are cost-effective, environmentally acceptable, and reduce energy consumption or demand. Do I have that correct?
That is what it says.
Would you agree that rooftop solar is an energy supply technology?
Actually, I'm not sure how energy supply is defined in this section, so I couldn't comment on that. What I would note, though, is the prior sentence specifically talks about investments in cost-effective energy efficient technologies and energy conservation programs, which solar PV certainly would not qualify as.
So I'm going to ask my question maybe then a different way, and to be clear, I'm not asking you for a legal opinion. And so I would say hit the pause button on thinking about the statute for yourself just for a minute. Would you agree as an expert or disagree whether rooftop solar is an energy supply technology?
I'd certainly agree that rooftop solar is a generation technology. But again, I can't comment on quote unquote energy supply.
Okay. Would you agree that rooftop solar reduces a customer's household's demand on the utility grid?
So it doesn't reduce household internal demand, but it does reduce the demand on the other side of the meter on the utility grid.
Thank you. And I'm not going to reference a Georgia Tech study, but it was speculated yesterday that solar actually increases a household's electricity usage. Did you hear that testimony yesterday?
Yes, I did, and I'm familiar with studies such as that.
What percentage, in general, in your expert knowledge, does a rooftop solar system offset a household's electricity usage? Is it 50, 60, 70%, somewhere in that ballpark?
Yeah, so I think it's worth sort of clarifying what's being talked about in a lot of these studies where they talk about increased usage. They're generally talking about increased household usage, not increased grid usage. So the solar PV, it's generally sized to about 75% to 100% of total household annual usage. And so it does provide a lot of reduction in purchases from the grid. But along with that often comes, rebound effects where customers, feel like now their energy is, free because it's from the sun, so they'll consume more, or they may invest in other electricity intensive uses like electric heat pumps where they previously had a natural gas furnace, or they may invest in electric vehicles that are now replacing their fuel consumption. So, it's always hard to sort of tease out how much is sort of, I guess what you might call just increased usage versus sort of new end uses that a customer has. But there's certainly a lot of behavioral studies that indicate that you probably do get increased electricity usage from many customers when they put on solar. On the flip side, you could have some customers who now become ultra focused on energy usage because they're providing their own energy. And so they may go to extra lengths to reduce their electricity usage because they like to see, their energy meter spin backwards or something like that. So it could go, either way. But but there are some studies that seem to indicate that the predominant direction is to be one of higher usage at the household device level.
With the net effect on the grid and on the utility being a reduction in demand, correct?
Yeah, I would expect that there would be a net reduction during most of the hours. You could have some hours where you have this reverse demand problem if there's too much exports. If you have, a high number of solar installed in a particular area, you can basically increase new peaks from the energy being exported back on to the grid. But in most cases, in low adoption areas, you'll see a demand decrease, I believe.
And you understand in this case that the company's evaluation of the programs, both in terms of cost effectiveness and in other areas, was exclusively focused on self-consumption of behind-the-meter generation, correct? Not exports.
Yes, that's my understanding.
Are you familiar or not, and I'll throw this out there and we'll see, but are you familiar with the company's combined heat and power or CHP behind the meter EEDSM program?
Yes, I am.
And what about the company's Power Share Backup Generator EEDSM program?
I'm not familiar with that program.
So then, as related to the CHP program, you understand that similarly that program, and maybe you'll take my word for it or not, that the Power Share likewise also relies upon self-consumption of behind-the-meter generation, correct?
I don't know if I'd say relies upon. Certainly it does reduce purchases from the utility, but as I discussed in my rebuttal testimony, CHP is kind of more similar to the solar domestic hot water systems, where it's providing useful heat to reduce the need for electricity or natural gas to be used to provide thermal industrial process needs. And because it actually reduces those needs, I think it could be reasonable to consider CHP and EE program, but also note that it's a bit of a gray area. There are a lot of jurisdictions who wouldn't consider CHP to be an EE program. California, for example, there were CHP incentives, but it was a completely separate program. It wasn't ever rolled into the EE world.
Thank you, Mr. Horry. Just give me one moment if you don't mind. Yes, sir. I'm going to email out to you Horry Cross Exhibit number 4 at this time.
How much longer do you have, Attorney Wilburn?
It all depends, doesn't it, Mr. Chairman? It's probably another hour.
All right. We're in recess until 2:20. Good afternoon, ladies and gentlemen. Welcome back to the Public Service Commission of South Carolina. We're here in dockets number 2021-143E and 2021-144E. Present in the hearing room, we have Commissioners J. Williams, C. Williams, Powers, Belzer, Thomas, and joining us virtually, we have Commissioner Caston. Attorney Welborn, if you would please proceed.
Thank you, Mr. Chairman. Mr. Horry, are you still with us? There you are.
Yes, I am.
Good. I have emailed out Horry Cross Exhibit 4, and if you'll please let me know that you have that. This is your, and confirm this, but is this your direct testimony filed in the generic NEM docket?
Yes, it looks like it.
Mr. Chairman, I would ask that this Horry Cross Exhibit number 4 be entered into the record as the next hearing exhibit.
Mr. Chairman, we have no objection to this. I would respectfully request that the entire testimony be entered into the record, but we have no objection conceptually.
Well, I mean, that's a bit of an objection. All we have here is Horry Cross Exhibit 4. It is 2 pages. Do you have the entire, I mean, do you object to him introducing the 2 pages, or what's the basis for the entire testimony?
Yes, sir. The basis for the objection is just this, it's taken out of, or potentially taken out of context without the entire testimony. This is just not sufficient context. We would have no objection if Mr. Welborn wanted to supply the entire testimony, shortly after cross-examination. I'm sure there's a
well. Let me say this. I appreciate your timely objections. That's a good way to do it, so you won't miss anything. But he hasn't asked any questions yet, so we don't know. At least I don't know that it will actually be taken out of context. Maybe it will. Maybe it won't. I don't know. But if you believe that it is, I think it'll be appropriate to make the objection at the time.
Well, Mr. Chairman, while he's not asked any questions yet, he has asked that this small excerpt be entered into the record.
Okay. So do this for me. I'm inclined to admit the evidence into the record. If you feel like he asked a question that puts the entirety of his testimony or places it out of context, please make the objection at the time.
Okay. Thank you, Mr. Chairman.
Yes, sir. So Horry Cross Exhibit number 4 will be marked and entered into the record as Hearing Exhibit 9. Hearing Exhibit 9. Please proceed.
Thank you, Mr. Chairman, and thank you for that directive. I would just, real quick, you see in the margin, it's 178 pages, and we're asked to provide 15 copies, and, next thing you know, we've got a backup printing truck up to the commission. So we're trying to be efficient and environmentally responsible. So anyways, Mr. Horry, do you have that exhibit in front of you now?
Yes, I do.
Thank you. And if you would, flip over to page 2 of that exhibit. This is page 11 of 178 of that pre-filed testimony. There's a highlighted, it's just that last full paragraph. And what I'm going to do is just read that, and you tell me if I read it right. And then to avoid me taking it out of context, I'll let you, tell me what you think about it. But so there you say, solar systems or any demand-side management DSM options reduce customer bills through reductions in the amount of electricity the customer needs to purchase from a utility. At the same time, this reduced usage results in lower costs for the utility to provide service because of lower power procurement or production related costs, as well as lower generation plant and delivery equipment costs. Did I read that correctly?
Yes, you did.
Do you stand by that statement?
Yes, and I guess just to add some context that may not be totally clear from just the excerpt. My recollection that this is really addressing how should solar systems be evaluated and how can you use marginal cost to evaluate solar systems. And so what it's saying is you can evaluate solar systems the same way you evaluate demand-side management systems in terms of using marginal cost and looking at the change in loads or demands caused by the solar system. I will note, though, just to be clear, I'm not saying that solar systems are demand-side management. I'm just saying you can use the same analysis methods and inputs to evaluate solar as you do demand-side management options.
Yes, sir. Thank you for that.
Mr. Chairman, again, just to provide proper context, and I'm not asking that Mr. Wilburn print out 15 copies of the 178-page testimony. I believe maybe an electronic copy could be submitted. But pursuant to Rule 106 of the South Carolina Rules of Evidence, I would require that the entire copy of this documentation be provided to the Commission for evidence.
Mr. Chairman, it's your call as to whether that rule requires, permits an adverse party to require this, as long as it is in fairness to be considered contemporaneously with it. And I don't object one way or another, but I'll leave it to you as to whether that would be necessary in this case.
Right, yeah, I'm trying to work through it in my head. I mean, I heard the questions that you asked, and is there something being taken out of context that require the entire 170 plus pages to be entered contemporaneously with this excerpt? Has fundamental fairness been violated?
Yeah, absolutely, Mr. Chairman. I'm certainly happy to respond to that. This is, I believe it's the third day of hearings, and we may go beyond today. I think we all understand that these are extremely complicated matters. Any one detail could very easily be taken out of context. Mr. Wilburn has highlighted a sentence from Mr. Ori's previous testimony, which I have no objection to. But to take this one sentence out of context without giving anyone sufficient amount of time to review the entire 178 pages, and while I appreciate Mr. Wilburn's giving Mr. Ori the opportunity to provide some context, that may or may not be sufficient. This is a spur-of-the-moment decision, and I do believe that fairness requires the entire document be entered into the record. Further, Mr. Chairman, I think that Mr. Wilburn conceded he was amenable to that. I'm not sure that any party would be prejudiced by the admission of this into the record.
Mr. Chairman, I would push back just a little bit. I think to the extent, you introduce all this extraneous testimony into this particular record, that could be confusing in terms of the record, including this, extraneous unrelated material into the record. I'm not even sure in this moment what that 178 pages includes, likely a number of exhibits and that kind of thing.
Right. Well, I guess I agree with you. So let's just sort of walk through it practically speaking. So Horry Cross Exhibit number 4 has been admitted into the record as hearing exhibit number 9. And you submitted this to us with highlighted portions, right?
Yes, Mr. Chairman.
Okay. And you're asking for 178 pages to be entered into the record is essentially hearing exhibit number 10. Is that correct?
Mr. Chairman, at your discretion, I'm happy if it's the subsequent exhibit or if you wanted to amend Exhibit 9 such that it included the entire testimony.
Okay, and so let's say it's hearing Exhibit 10. So that's, I say, it's entered into the record, right? Are you not going to go through during recross and rehabilitate your witness on any issues that you think have been mischaracterized?
I absolutely may, Mr. Chairman. This is something that I'll look at, and I've not yet made that determination, but it's entirely possible I could.
Okay, well, let's see how all this plays out. Hearing exhibit, we're on number 10. So Mr. Ori's testimony, direct testimony and exhibits in docket number 2019-182E will be marked and entered into the record as hearing exhibit 10 in an effort to preserve fundamental fairness to the witness's counsel so that no statements will be taken out of context.
Thank you, Mr. Chairman.
All right, thank you. Please proceed.
Thank you, sir. All right, Commission and Mr. Horry, we'll switch gears just a little bit. Mr. Horry, would you agree that in South Carolina, some customers are all electric and some customers may take gas service for certain things within their household?
Yes, I agree.
And in this particular case, under these programs, electric, space heating, and water heating are required components or requirements of the program for participation. Is that correct?
That's correct.
And the company's made reference to Schedule E, or rather Duke Carolina has made reference to Schedule RE in its application, and that's the all-electric rate schedule. Is that correct?
That's correct.
And Schedule RS, in contrast, is not the all-electric rate schedule. Isn't that right? Isn't that the mixed gas-electric rate schedule?
Yes, it is.
In your free ridership calculation, in this case, that's based on forecasted solar installations for customers on Schedule RS. Is that accurate?
Yes, that's correct.
And you
And
agree-
as I spoke,
Sorry.
as I explained in my testimony, the reason I did that is I wanted to avoid the risk of any solar incentive charge that may have been sort of on Duke's mind, sort of affecting the forecast that I use. So I wanted to make sure that I had data that didn't include any solar PV incentive. And so that's why I used the RS customer data. But I also note that if you look at the sort of the cost effectiveness or the compensation, I should say, that would go to an RS or an RE customer moving to solar, it's really the same. So there really is no sort of bias introduced by using the RS customer data instead of the RE customer data for coming up with the free rider estimates.
So your position is that they're essentially comparable for purposes of your free ridership calculation. Is that correct?
Yes, that's my position.
Thank you. I've just emailed out Horry Cross Exhibit 5. Please be on the lookout for that.
Okay, I have that.
Thank you, Mr. Horry. Now, I'm going to give the commissioners just a moment so that they can see what we're seeing. In this exhibit, Mr. Horry, ORS asked for participation in the BYOT program, and they asked for separate statistics for Schedule RS customers versus all-electric customers. Isn't that right?
Yes, that's correct.
And would you agree that the reason for that, I'm sorry, our court reporter needs to pause. Isn't the reason for that because all electric customers are eligible and the Schedule RS customers are not eligible for the programs, correct?
That's correct.
So I've broken down, Mr. Horry, the response of the companies. If you look at pages 3 and 4 of this cross exhibit, you'll see sort of the breakdown of the customers as provided in that DR response. Do you see that?
I do.
And so you've got RS customers sort of on one part of the pie, the wedge. You've got all electric customers as another part. And then as a third part, you have all electric customers that are also BYOT participants. Is that correct?
Yes, that's correct.
It stands to reason, doesn't it, that if you consume more electricity, you would benefit more from participating in a program that offsets your demand on the utility. Wouldn't you agree with that?
I'm sorry, can you can you repeat the question?
It stands to reason, doesn't it, that if your household, if you consume more electricity, for example, if you're an all-electric customer, that you would stand to gain more from participating in a program that offsets your electricity demand on the utility, correct?
So can you clarify, are you talking about participation in BYOT?
No,
Are you
sir.
talking about participation of, purchasing a solar PV system?
if you are an all-electric customer, if you rely on the electric utility for 100% of your household's energy needs, doesn't it stand to reason that such a customer would gain more than a mixed gas-electric customer from participating in a program that offsets part of your demand on the utility? I mean,
Again,
I was just going to say, you can agree or disagree with that. I'm putting the question out there for you.
okay, so I would say if we're looking at the solar PV, the size of the customer and the amount they consume, as far as adopting solar is really irrelevant. The larger customer may adopt a larger size system, and the smaller customer may adopt a smaller size system. But their paybacks, are likely comparable unless there are vast differences in the PV sizes. For the BYOT, I'm not sure if customer size even has an impact, because I think the incentives, and you can correct me if I'm wrong, but I believe the incentives are just a sign-up incentive and then an annual participation, or maybe it's a monthly participation credit, but I don't think that's linked to the amount of load reduction you provide. I think it may just be that you provide some load reduction, in which case the size of the customer is not relevant to the sort of the benefits that they're providing or they receive.
I want to make sure I understand your testimony correctly, Mr. Horry. So if all the appliances in your house are electric, you have electric water heating, you have electric space heating, don't you have more to gain from a program that offsets your electricity demand on the utility?
Well, again, I was saying, when you look at the payback, like, does it make sense for a customer to purchase solar PV? That payback isn't affected. The size of the system may be affected, but the payback, which is all I've really, I need to look at when I'm looking at the free rider question, that's not affected by the size of the customer.
I'm not talking about free ridership. I'm talking about customers who are all electric. Is it your testimony that you disagree that all electric customers have more to gain from participating in a program that offsets their electricity demand than a mixed-use customer?
Well, what I'm trying to just keep clear is that absolute dollar amount isn't critical for free riders. To be sure, there could be larger dollar savings that they could obtain, but it'd be through a larger dollar investment or a larger obligation to the solar leasing company in order to get those savings.
Thank you, Mr. Horry. I've just emailed out Horry Cross Exhibit number 6. If you would, please let me know when you see that pop up.
Okay, I have it now.
Thank you, Mr. Horry. And is this an excerpt from your testimony given in the Solar Choice proceeding?
Yes, it is.
Mr. Chairman, I would ask that this be entered into the record as the next hearing exhibit.
Mr. Chairman, I'm going to wait until Mr. Wilburn asks a question on this, and then I will evaluate whether or not I believe the appropriate contextualization is contained within this, though I hesitate to say I may stand up in just a second.
No problem at all. Horry Cross Exhibit number 6 will be marked and entered into the record as hearing exhibit number 11.
Thank you, Mr. Chairman. Mr. Horry, I would refer your attention down to footnote 9. And if you'll bear with me, I'm going to read through that, and you tell me whether I read it correctly or not, if you would, please. For customer generators who cannot participate in the winter BYOT program because they do not have electric space and hot water heating, there is a possibility they could provide winter peak reductions without receiving the winter BYOT program payments. However, given that those customers will not have both electric space and hot water heating, it is unlikely that they would have peak loads near what I assumed in my cost reduction analysis. It could therefore not provide cost reductions near the values that I presented. Did I read that correctly?
Yes, you did.
Mr. Chairman, this is Mr. Bateman for ORS. Again, Mr. Chairman, I can't commit that on redirect I may want to ask questions related to this, though I would like the opportunity to review this and also the remaining, pages of the 43 pages of testimony. And as a result, I'd respectfully request that the entire 43 pages be entered into the record to provide for sufficient contextualization and fairness in the event I may want to ask questions on it on redirect.
The revised direct testimony exhibits of Brian Horry on behalf of the South Carolina Office of Regulatory Staff and dockets number 2020-264E and 2020-265E. We marked and entered into the record as hearing exhibit number 12.
Thank you, Mr. Chairman.
So, Mr. Horry, your testimony in that case, which wasn't that long ago, was that there was a material difference between all electric customers and mixed use customers. Isn't that right?
Well, I mean, let's take this in context. What I was estimating here is what the potential benefits could be from a winter BYOT program. And I compared that to the incentive that it looked like would be given to customers who participate in the winter BYOT program. And basically those two amounts were roughly the same. So my conclusion based on that was even if you factored in the winter BYOT program in the evaluation of solar choice metering tariffs, it wouldn't affect the cost shift because the benefits you're getting are basically being funded by the incentives you're paying out to the BYOT program. And so the point here is the solar choice metering tariffs apply not just to customers eligible for the winter BYOT, but to other customers who aren't eligible. And those customers, it's unlikely you would see the same kinds of load reductions from them that you see from the winter BYOT customers.
In other words, they would not have near the peak load reductions that the mixed use customers would have. Correct?
That's right. And again, this is looking at peak load reductions, and it's not looking at, and maybe you're not taking it there, but I just want to make sure it's clear. This has nothing to do with the free ridership calculation, nothing to do with the payback periods for the different customers or the likely adoption for all electric versus non all electric customers.
Speaking of free ridership, you based your free ridership figure on forecasted adoption rates, right, for 2022?
That's right.
But then you said in Sir rebuttal, the company's analysis should not be based on forecasted adoption rates. Isn't that right?
Can you point me to the Sir rebuttal
You
testimony
said,
you're referring to?
isn't it correct? I'm sorry, I don't have that reference in front of me, but didn't you say that forecasted adoption rates should not be relied upon? Instead, you should look at total prevalence in South Carolina. Do you remember that discussion in your Sir rebuttal testimony?
I don't. I think you'd have to point me to that.
Yes, sir. Give me 1 minute. On page 21 of your Sir rebuttal testimony, beginning at
Okay,
line
I see that now.
beginning at line 6. or rather beginning at line 7, you say this perspective is not the correct way to evaluate future market uptake or customer adoption propensity. Instead, one should consider the total prevalence of solar PV. So in other words, you're saying that the company, rather than looking at customer adoption rates, we should be looking at total prevalence. Is that correct?
Well, I think you prefaced, well, I'm sorry. Go ahead and ask your question again, because I was remembering something from a question, something stuck in my mind from before we found this, but I want to just answer the exact question you're asking. So if you could ask it again.
Thank you. You state, beginning at line 7, that this perspective is not the correct way to evaluate future market uptake or customer adoption propensity. Instead, one should consider the total prevalence of solar PV. So let me rephrase that, and you tell me whether you agree with my rephrase or not, if that's okay.
Okay.
You're saying that the company should not focus on or use customer adoption rates, but instead should look at total prevalence. Is that accurate?
Well, in a way, but to expand on that, it's when looking at the likelihood of future adoptions. What I'm saying, you can't just look at how many solar panels got adopted in one single year, in particular in a COVID-influenced year. But you have to look at sort of the solar market, how far it's evolved in total, and that's what I mean by looking at the total prevalence of solar PV.
But you yourself based your free ridership analysis on forecasted adoption rates, didn't you?
Right, I use forecast adoption rates, but I think you're sort of confusing the two issues here. The forecasted adoption rates I use, which were provided by Duke, are based on predominantly, I believe it is payback period analyses. So it's a completely different way to develop an adoption forecast. Now, presumably there is some S-curve influence in there. So there is some incorporation of how evolved the total market is. That's usually the way you do an adoption forecast. I don't really recall the details of that in particular offhand. But I believe that if they did their forecast correctly, it would have looked at both payback and the state of the solar market in coming up with that adoption forecast. And the state of the solar market would be basically that total prevalence that I discussed.
But the fact of the matter is, you based your free ridership analysis on forecasted adoption rates and then said in rebuttal that you shouldn't look at forecasted adoption rates. And that analysis was based on electric gas customers rather than all electric, correct?
Okay, a lot to unpack here. So first thing is you say I based my adoptions. Actually, can you just restate the first part of your question so I can address that?
Isn't it correct that you based your free ridership analysis on forecasted adoption rates?
Okay, so yes, I based my free rider analysis on forecasted adoptions. But what this particular section that you quoted is, it's saying don't use just an adoption forecast to basically create your adoption forecast. You see the difference? Saying don't use the adoption forecast as the only information to come up, or actually I should say don't use a past adoption number for 1 year to come up with your adoption forecast. I don't say don't use adoption forecasts. I'm just saying that what Duke has implied in the rebuttal testimony of witness Duff is an incorrect way to use an adoption forecast from 1 year to imply future adoptions in other years.
I don't have any further questions for this witness, Mr. Chairman. Thank you. Excuse me. Thank you, Mr. Horry. I do appreciate it. I didn't mean to end so abruptly, but yeah, I do appreciate your time.
Thank you.
Commissioner questions. Mr. Horry, I have a question for you.
Yes, Commissioner.
Earlier, you were asked about the difference between a solar-powered water heater and solar PV. Do you remember that line of questioning?
Yes, I do, Mr. Chairman.
I'm having a hard time understanding the difference. So I want to ask you to help me out a little bit, if you don't mind.
Sure.
So could you state again the difference between a solar powered water heater that is considered energy efficient and solar PV, which you do not consider energy efficient?
Certainly. So the solar hot water heater, it's actually making, your existing hot water heater more efficient because it's preheating the water. So you look at the amount of energy you're consuming as a household to heat water, it's a lower amount than when you installed the solar hot water system. Solar PV, on the other hand, when you look at your hot water heater, you're using the same amount of electricity to create that hot water. In fact, everything in your house is using the same amount of electricity, maybe even more. Maybe you're using some stuff more, but let's say it's the same. What that solar PV is doing, though, is it's basically an alternative source of electricity for your home appliances. So you end up purchasing less energy from the grid, but you haven't actually made anything more efficient. You haven't improved the efficiency of your household.
Okay, so I like to use hypotheticals, and when I think about just what I use in my home, I have an electric stove, range, refrigerator, microwave, light, HVAC. If some innovator, creator, Elon Musk, came up with a way to make all of those items more efficient using solar in some way, shape, or form, would you consider all of those items energy efficient?
So I think that's a bit of a gray area. It kind of depends on how the solar is making those more efficient. Like if somehow the solar were integrated with the electric stove, so they're kind of like a single device, I think that would clearly be energy efficiency. Again, it's kind of the nature of solar PV just being up on the roof, having no synergies at all with anything that's going on in the house, but just being another generator. It's almost like just sticking a diesel generator behind the meter. It could also produce electricity, or let's say an ethanol fuel generator. So it's using a renewable fuel source. It's also reducing, total household purchases, but it hasn't really made anything more efficient.
I understand the words you're using them, and it just appears to me that you're taking a pretty hard line on what's energy efficient and what's not. I guess what I'm having a hard time understanding is the difference. The sun is being used to decrease the amount of power that the customer is using. When it comes to the water heater, because in your opinion it makes the system more efficient by using less energy to do the same thing, is being defined as energy efficient, whereas because the panels, the solar voltaic panels are used to generate energy, the customer is not necessarily using less energy, just energy from a different source, but that source is the same, the sun. So is it not an artificially drawn distinction?
No, I wouldn't say it's artificial. I think it's a critical distinction, because once you say all we need to do is see the utility have to provide less power to call something energy efficiency, then I think that totally blows away what the industry has always thought of for energy efficiency. I think I've given my direct testimony this kind of whimsical example of I take an extension cord and I plug all my appliances in to that extension cord and I run it across the street to my Santee Cooper neighbor's house. I'm using the same amount of electricity. I'm buying less now from the utility, is that energy efficiency just because I have a different source for my electricity? And I think it's, it's pretty clear that it isn't, regardless of the source. What I'm worried of is the precedent that all you have to do is say utility reductions rather than actually see any efficiency improvements. That's my concern with the definition, like Duke is trying to propose.
Okay, well, I mean, historically speaking, doesn't all innovation usually upset well-established, accepted industry practices? I mean, it's new, so that's not to be unexpected that innovation may upset standard practices.
Yeah, I mean, certainly, but I think there's also the other side of that coin, which is maybe no one's done it because it's just not a good idea, right? Maybe the road less traveled is less traveled because there are snakes and wolves along that path. I think if this commission is thinking about sort of agreeing to what Duke has proposed, I think you just need to keep in mind what all the potential implications of that might be. And
Well, what are those? Not to interrupt, and why? I mean, because I'll tell you this about you that I appreciate. You are an excellent witness. You've testified before this commission several times, and you were very patient with working through at least mine. I think all parties and commissioners' hypotheticals. And so I'm really trying to get this right. Why is this a bad idea? Because it's very clear that you and the party you're working for thinks this is a bad idea.
sure. So, I think I highlighted one of these issues, and we won't go into all the statutory conflicts and all of that because that was dealt with yesterday. But in addition to those, I just really have a strong worry about defining energy efficiency as being totally divorced from what actually happens in the house and just looking at what happens to the grid, what happens to utility. Because I gave my silly extension cord example, but what if you have like a transmission line that's built to a large industrial customer? Should Duke, and let's say it's a third party who does that, or let's say an industrial customer decides they need to build their own generator, should Duke now earn shareholder incentives because they decide to offer that customer a $1 incentive so they can get that counted as an E program? It's kind of this perfect storm of three factors that really, have me concerned in this case. And, I wrote these down just so I make sure I remember them. One is, sort of EE only being sort of looked at from the utility perspective, and I've gone over that a little bit. The other is using, as proposed, the UTC, or utility cost test, the UCT, as the only test to evaluate cost effectiveness, because bundling the UTC with the fact that shareholder incentives are the way that or I should say that shareholder incentives are based on the UTC, has now basically made that a utility profit maximizing test. Right, all that's involved is what are the utilities costs and what are savings, and the utility gets a share of the difference. There's nothing in there about the customer. There's nothing in there about the fact that the solar customer has to commit. There's either buy the solar panels or commit to a solar lease. And there's nothing in there about the fact that other non-participants are going to end up actually paying for that solar system. Sure, some of it is quote unquote funded by cost savings, but we know there still is a cost shift. And so that cost shift is going to be funded by other South Carolina customers. And then they want to throw an incentive on top of that. Now, we already came out in a solar choice metering tariff knowing that, okay, this looks like the best we can get. We reduce the cost shifts as much as we think we can. And now this proposal just walks all that back. It gets us back to incentives for the participant that are basically the same as what we had under NIL. And And so, there's kind of a lot of fairness issues involved here. And, I didn't even bring up the cost shift stuff in my direct testimony because I just put on my energy efficiency hat and looked at it straight as an energy efficiency program. And even there's these issues of how you define, where do you measure cost effective or where do you measure efficiency? Is it at the device level or is it at the utility level? Do it at the utility level, any kind of generator, any kind of transmission, any kind of other supply now gets classified as EE, which no one in the EE world thinks of as EE. Bundle that with the shareholder incentive. There's going to be a lot of incentive for Duke to be pushing this. And then, basing, well, I guess I went over those. I'm sorry, I kind of rambled a bit.
No, it's fine. I heard two. Was there a third? You said you wrote three things down. Did you go?
Yeah. So one is the use of the utility cost test alone. That's one concern. Two is the shareholder incentive based on that UCT. And the third is opening up the definition of energy efficiency. So it doesn't actually have to be anything efficient in the house, but it's any kind of reduction of utility loads counting as EE.
Right. Well, what else let's say we open that definition, but what, other than solar PV, I mean, do you think folks will start using other renewable sources at the residential level?
At the residential level, I could see like any kind of backup generator a customer wants to have would now be EE. Maybe it incents customers to put in other kind of self-generation system. But, here's my real worry, having gone through the energy crisis in California. When we're looking at market restructuring in California, all of us utility types, we're involved in looking at what do we think is going to happen in the markets. What do we forecast the impact on prices are going to be, et cetera. We had no vision that what Enron would do would ever happen. So, we didn't see what we were pushing for ever resulting in the kind of problems that happened in California. And that's one of my concerns here. It's such a big change. Maybe I lack of the imagination to come up with what all the potential problems could be or what the worst problem could be. But I'm worried about that. And I see there are clear problems with doing that. So I just want to give the commission that caution, because it's not only going to affect what happens in South Carolina for these customers, it's also, I fully expect to affect all solar PV. I think they'll extend it to all solar customers. I think the solar industry, as I mentioned, will then push it to Dominion. I think they'll push it in North Carolina. I think the solar industry probably has a playbook on how to sell this across other jurisdictions across the nation. So, it could have a big impact. And so I think you have to really be careful on whether you want to give it any leniency and give it the benefit of the doubt before approving something like this.
So would you agree that the Solar Saver, the 3S program, is it fair to describe it as a Trojan horse?
That's a great question. When I first read about this, the thing that popped into my head was a Pepsi can.
Was it what now?
A can of cola, a can of Pepsi. And the reason is when I was in college, Michael Jackson tour, that was the biggest thing. And there's no internet, so people couldn't sell or scalp tickets legally. But what people would do is they would advertise a can of Pepsi for $200 or $500. And with that would be 2 free tickets to the Michael Jackson concert. And that's kind of what popped into my mind here. It's like, we're just adding something on to a program just so we can sort of legally push it through.
All right. Thank you for answering my question, sir. Commissioner Powers.
Thank you, Mr. Chairman. Mr. Horry, I think you may have got kind of thrown under the bus yesterday by Mr. Lawyer. I asked him a question. He said to ask you. The cross exhibit number 1 that talked about the risk of rising energy costs for all Duke customers kind of fits in with what I wanted to ask. How long would it be before the non-solar users would see a benefit from this program? You say you didn't measure cost shift, but is there a cost shift there that you see?
Sure. So, and that's a great question. So, we know there's a cost shift from the solar choice metering tariff. I mean, Duke has always said that their new tariffs reduce the cost shift, but don't completely eliminate it. And remember, in the energy efficiency world, we have to think about the cost shift from the marginal cost perspective, not the embedded cost perspective. And so there's never been any indication that the cost shift from a marginal cost perspective has been eliminated. So given that we know any solar that's adopted, there's going to be a cost shift impact on non-participants. And we further know that this program is asking for an additional incentive for solar customers, roughly $3,500 per installation. And that's going to be funded by all ratepayers, mostly non-participants. So essentially that's just adding on to the already existing cost shift that's imposed on the non-participants.
Okay. Well, some of the testimony is that long-term it'll benefit all ratepayers. Is there any way to quantify how long that would be or what that benefit would be?
So, one of the things to keep in mind is when you look at sort of all costs, that's when I think you need to look at the TRC. You look at, total expenditures for energy. And since this program fails the TRC test using Duke Solar numbers, we know that it's not going to reduce total energy spending in South Carolina. It's only going to increase it if you adopt the program. So there's never going to be sort of a crossover. It's always going to be negative.
Okay. Thank you very much. That's all I have, Mr. Chairman.
Commissioner Caston.
Chairman, thank you. Good afternoon from South Carolina. I guess it's good afternoon in California now.
Good afternoon, Mr. Commissioner. I believe confusion or some confusion is coming into play, and I want to make sure I understand it. The distinction between reduction of energy from the grid versus a real reduction in electricity used from the source. Let me say it this way and tell me if I'm understanding it. If all of the homes had energy efficient appliances, those energy efficient appliances would serve the same purpose, do the same thing, but they would use less electricity, correct? That's right.
So, I think Mr. Torini asked you the question about the solar water heater, and I know Chairman Williams was asking about that, and I thought some about that. So relative to this distinction, I think, if I understood you, the distinction between a solar water heater versus a solar panel is, as I think I understood what you were saying, is that the solar water heater provides at the source the same service as an electric or gas water heater. The source being the water heater itself. That is the source. Correct? So
yes.
it provides, I'm sorry.
No, I agree.
It provides the same. Excuse me, go ahead.
No, I think we're suffering from internet lag, so I apologize. Go ahead and continue.
So the solar water heater provides the same service as an electric or gas water heater at the source, it being the water heater itself, the tank that stores the hot water. But while solar panels produce energy, they do not do the same thing using less electricity at the source, and the source being the panel. It's not about the grid, but the source level. Is that correct?
Yes, or another way to think about it is sort of using less energy at the device or the end use level. You often hear it discussed using those terms as well.
So I've heard that the definitions of energy efficiency and maybe even conservation and everything else is shifting or changing. Maybe it is, and I don't understand that or know it, but I know what I've understood, or I thought I understood energy efficiency to mean, conservation to mean, and such as that. Who determines the definition of energy efficiency, conservation, and such terms as that?
You know, Commissioner, that's a great question, because I actually searched for a definitive definition. And, you know, when you look at documents, like even the legislature, there are a lot of defined terms in there. Energy efficiency is not one of those terms that gets defined. It's sort of a term that's just, I think, understood based on the plain reading of the words, you know, energy efficiency. Just like demand side management, it's a plain reading of, you know, management. It's doing, you know, load management, demand response, as opposed to, you know, increasing efficiency. So it tends to get defined by, you know, by just the industry users, and by the way, you know, different jurisdictions, you know, are you know, rolling out energy efficiency and demand response and DSM and conservation.
Okay. And I think Mr. Worman's question, and I was trying to make sure I understood what you were saying relative to adoption forecast versus prevalence of solar. I think I understand it. Were you saying that to forecast whatever adoption rates, to forecast adoption rates, it is not simply looking at what adoption rates have been in the past, while that is a factor, but the prevalence of solar in the particular area or service area. In other words, if it's 5% prevalence, the adoption rate may be higher. If it's 90% prevalence, the adoption rate would be less. Is that what you're saying? Is that what that meant?
Yes, I think that's a good way to think about it. It's the total prevalence. It's the total market that's going to indicate how likely future adoptions are going to be. You can't just look at a single year. You have to look at, you know, all the adoptions up to that year.
And I'm probably plowing the same ground you've answered 100 times, but the EIA definition of energy efficiency, do you agree with that definition?
Yes, I think that's a good definition.
And energy efficiency relative to that definition, not some other definition that's kind of moving, but that definition is the source being the appliance, let's say appliance, the LED light bulb, the energy efficient refrigerator, the 20-SEER HVAC unit. It is a device, an appliance that does the same thing. It cools my house. It it lights my room. Equal to or better than the previous one I had, but it does it using less electricity because that piece of equipment simply uses electricity because it is more energy efficient. Is that correct?
That's correct. Yes, I think that's a good way to look at it. I'll throw in one little twist, and that is something like increased insulation. Because the insulation, it itself isn't changing the way energy is used in the house, but it allows the HVAC, the air conditioner to run less in the summer and, the heater to run less in the winter.
Makes sense. I understand that. And the distinction you're saying relative to solar panels is it generates electricity, but that's what it does. It generates electricity. It's not efficient or non-efficient. It simply generates electricity. Now, if you're talking about is it a reduction on the grid, it can be or could be. Is that what you're saying?
Yes. So, I think if the commission deemed it appropriate to give an additional incentive to solar, that could be viewed as under some other kind of program, like a small generator incentive program. But what I'm particularly concerned about is, first, it doesn't pass the cost effectiveness test, but if it did, I still don't think you'd want to classify that as energy efficiency. Just classify it as something else and then separately evaluate whether that something else is deserving of these shareholder incentives and net loss revenue recovery. But I'm worried once you stamp something with the moniker of EE, then all this baggage comes along with it.
Understand. So relative to reducing demand on the grid, if all appliances, if home A had a high efficiency HVAC unit, all the appliances were energy efficient, all the bulbs, and it was a well insulated house, that in itself could and should reduce the demand on the grid, correct?
Yes, that's correct.
And a solar panel, when it's working during the day, sunny day, whenever, the customer can use that energy to offset energy on the grid, correct?
That's right. It's not changing usage in the house, but it's changing the purchases from the grid.
Okay, that's what I was trying to understand too. In other words, they both can and will reduce energy demand on the grid, but they're distinctly different if I'm understanding what you say. The others use less electricity. The other simply generates it. That's it. Is that what you're saying?
Yeah, I think in a nutshell, that's what I'm saying. And I worry that if you open up EE to include generators, then, I gave some examples to Chairman Williams about what could happen, but I could also see cases of, let's say, third-party generators that are currently compensated based on, PURPA. Now they could locate, let's say, near a utility substation, claim that they're reducing utility loads, show that they're a renewable resource, and now say they should be getting EE incentives. And Duke might chime in and say, sure, and give us shareholder incentives along with that.
And don't let me put words in your mouth, but what it sounds to me as though you are suggesting that the definitions of EE, DSM, conservation, we should tread cautiously when considering changing those definitions. Is that a fair statement?
Absolutely, Commissioner.
And the distinction between EE, energy efficiency, and DSM, there's a distinction, correct?
Yes, and it's a little confusing because there's two ways that DSM is commonly viewed. One is that DSM is energy efficiency plus load management resources or things like demand response. The other way to look at it is DSM doesn't include EE, but it's just the demand response, load management kind of stuff. So in the industry, it's kind of used both ways, so it can often be confusing.
Is the BYOT program, would that be considered DSM or EE in your opinion?
So in my opinion, BYOT is certainly demand response because it's looking to get these short amounts of peak load reduction just at certain times, whereas energy efficiency is something that's just there all the time, providing load reductions. It's not something that has to be dispatched. It's not something that has to be controlled by the utility. So because that BYOT is definitely a demand response program, not an EE program.
Fair. So I think I recall somewhere in your testimony concerned about a 20-year versus a 25-year life. And that's actually one of the questions I want to ask you. What is the difference with the proposed program and the existing solar PV programs that should allow the proposed program a 25-year life and the existing solar PV 20 years life?
I'm not sure there's actually is anything that justifies the use of a 25-year life if it's already been determined that solar PV should be evaluated with a 20-year life and not a 25-year life. I mean, I understand that Duke's program is looking to do a 25-year program, and so they're saying they need to evaluate over 25 years, but it seems like they could have just as easily done a 20-year program and evaluated over 20 years. And I'll also note that given that the cost of the program or the cost of the solar PV, it's really a one-time cost. By extending out the period of time you look at, you're just adding sort of more benefits in without adding any cost. So you're making the cost effectiveness tests look better. I'm not saying that's necessarily the reason why they decide to do that, but I'm just saying that that is an outcome of them using 25 years instead of 20.
Wasn't going to ask about the cost effectiveness test because maybe that horse been beat a lot, but do you believe the proposed program, as we discussed numerous times, should be evaluated relative to multiple cost-effective tests?
Absolutely, because, and maybe part of this is just, I went to school in civil engineering, which has a strong emphasis, as I'm sure you know, in sort of public interest, public good. I worked for a public utility, a municipal utility, and a public utility, where at least there we also believe that the public interest, public good was a large part of what we needed to focus on as part of the regulatory compact. And so I believe that when looking at energy efficiency programs, when you're looking at taking money basically from one group of customers and giving it to another group of customers, that you need to be sure that at the end of the day, the total for non-participants and participants, the total benefits are going to exceed those costs. I also worry that if a utility offers an incentive program, I think that may put some sort of, not a gold stamp on it, but make customers think that, this is probably a good idea for me to pursue, because utility, I don't believe they'd be offering programs if it was going to be bad for me. So I think there needs to be some kind of stewardship and evaluation of EE programs to make sure they really are in the best interest to the greatest extent practicable for customers, because individual customers aren't going to be able to do that, the math, the complicated cost effectiveness evaluations that we've been doing. All they see are their monthly bills, maybe their annual bills, and to a large extent they have to trust that what the utility is encouraging them to do is the right thing to do. And so I think the TRC test is the best way to sort of maintain that view of, is this program in the interest of the public? Now, if it is, the utility can certainly look at the UCT test, make sure it makes sense to them, and also, maybe prioritize their efforts based on UCT results. But I don't think they should be offering programs that fail the TRC test.
Understand. And by the way, I took civil engineering at Stanford East, Clemson University, or maybe Stanford is Clemson West. I'm not
maybe
sure.
we're Clemson West.
But,
certainly in football, we're nowhere near.
Well, I remember some of the same portions, especially on the benefits, cost, and efficiencies and such. Final question: If the program is adopted in a year from now, let's say 2 years from now, or a year from when it's adopted, whatever, the program proves not to perform as anticipated, what happens to the 25-year contracts and solar systems that have been installed during that period?
That's a great question. Obviously, the solar panels aren't going to come down off the roofs. They're going to stay there. Now, continuation of the BYOT, I mean, that part could be ceased, but I have a big question or concern about the upfront incentive payment. Because, I mean, I can just see the headlines saying that basically South Carolina Commission is taking money away from solar customers, right? They're not going to care that the program's not cost effective. They're just going to care that whatever money, whatever incentive they've received, that they get to keep that. So I can't imagine there would be any true up to, take that incentive back away from customers, because I think that would just, be terrible PR for the utility, and probably ultimately the commission. I think it would probably largely fall on the commission. So, the utility talks about a true up, and they, I see that happening for the utilities, net loss revenue recovery, or the shareholder incentives. But, even for those shareholder incentives, I think I mentioned how tough EM and V studies are. So I could see it dragging out at least a year, maybe 2, maybe 3, before you could even sort of evaluate it till you have an EM and V study that all parties would agree to. So I think it would be dragged out a lot longer than just the 1 year.
Thank you, Mr. Horry. You've been very good, and go Cardinal.
Thank you, Commissioner.
Mr. Chairman.
Commissioner Thomas.
Thank you. Mr. Horry, good afternoon.
Good afternoon.
I wanted to follow up just a little bit more on one of the questions that the chairman asked and part of the conversation you just had with Commissioner Caston. There's been a lot of talk about energy and electricity and just changing those words back and forth as if, sounds to me like sometimes they're almost being used interchangeably, and I don't see them as being exactly the same thing. To me, energy is one thing and electricity is something else. Energy is used to create electricity, whether it's by a solar panel or by the utility, and the source of the energy could be any number of different things. And just trying to relate that back to energy efficiency in the domestic water heater program as an example. The way I understand that is that energy is used directly to help heat the water, which ends up causing less electricity to be used. And to me, that's kind of the distinction as to why that water heater program is called an energy efficient program, whereas it's hard for me to say that this the solar panel program is an energy efficient program. Does that make any sense, or any thoughts on that?
I think you've got it, Commissioner. I don't think I need to add anything. Your sort of simple explanation, I think, is spot on.
Okay. Thank you. That was all I had. I appreciate it.
Commissioner Williams.
Thank you, Chairman Williams. Good afternoon, Mr. Horry. I think is it?
It is afternoon, thank you.
Okay. Time for lunch, perhaps. I have two questions, and one, just ask the question, if Duke had not applied for lost cost recovery and for shareholder incentives, would this be a good program from an energy conservation perspective?
No, it still wouldn't, because it still fails the TRC test and it fails the UCT test.
Okay. And we've talked a lot about energy efficiency and about demand side management, and maybe there was some conversation about behavioral management. So my question is, with the the marriage of the BYOT program with solar PV, it's my understanding that the BYOT program has the ability, and that smart thermostats, but also BYOT has the ability to have some behavioral modification request. Does that change? How does that sound to you? Does that change how you look at whether this is energy efficiency?
So what the BYOT program itself does is definitely just demand response, DSM. Now, I mean, there is sort of a subtlety here, and that is, in order to participate in the program, you have to have a smart thermostat. And the existence of the smart thermostat potentially could offer some small energy efficiency benefits, but it's not a requirement. Basically, it's just if someone has a Nest thermostat, potentially they could use its features to, turn off the heating and air conditioning when they're less likely to use it, etc. There have actually been sort of studies going sort of both ways, saying that programmable thermostats like that can provide energy efficiency. There are other studies that say it actually increases energy usage. Now, it may increase comfort, but it also increases energy usage, because you could have the case, let's say, where, you get up in the morning, turn on the heater, and then, you're off to work in an hour. So at most your heater was running an hour. If you had a programmable thermostat, what you may be able to do is have that heater go on like 2 hours before you wake up. So it is nice and warm and toasty when you get up. and then it turns off when you leave. But now that heater's been running for 3 hours rather than just 1 hour. Certainly it's more comfortable, but you've actually used more energy because of it.
So it sounds to me like behavioral modification does have a relationship to energy efficiency, but it could go either way. Is that fair?
Yes, that's a nice, concise way to summarize what I said.
Okay. Thank you very much. I appreciate it.
Mr. Horry, I have a couple more questions for you before we let you off the stand, or before there's any redirect or recross. We have 7 commissioners here, and all of us have various backgrounds and experiences which lead us to ask the questions that we ask and think the way that we do. And for me, a part of my background is just being from rural South Carolina and being raised to try to practice good common sense. And in doing so, there's not a time where I can check my common sense at the door, even in here. And what I'm having a hard time reconciling is all the work the parties put into creating this program. I think there are more than 5 parties that have come together to present this program to the commission, and I've seen the attorney from the self-described clean energy interveners work together with utility attorneys, which I've never seen before. And it just seems to me that there's a strong belief that this program, at least by that group, there's a strong belief that this program is a good program. Are you telling me that there's no way to salvage any portion of this program? Is it as bad as you say it is?
Yeah, unfortunately, given the avoided costs in South Carolina that are quite low, given that South Carolina really is a winter peaking area now, not a summer peaking area, solar is just not providing the same kind of value in South Carolina that it provides in other parts of the nation. So it's just not passing, the TRC test, as I've said, and even Duke has testified to. And also, from the utility cost test perspective, there's the issue of the free riders. And one of the things is we haven't even seen what adoptions look like under the new solar choice permanent tariff. So it's not clear that there's a need for such a program. I can understand there's a desire by the solar industry to have such a program. And I understand there's a desire by Duke to earn shareholder incentives and recover net loss revenues from the program. But I just don't see where it can be salvaged in the interest of South Carolinians at this point. Now, maybe in the future, the commission decides that other benefits should be included in the valuation of programs, CO2 benefits or something like that, or if it looks like the long-term forecast of energy prices in South Carolina is much higher than what's currently been adopted, then potentially a program could look good. But I think because of all of the emphasis on the cost shift by the legislature, I think you also have to pay attention to what happens to the non-participants in evaluating a solar program. And I think that's something that's a bit unique to a program that has solar PV in it because of Act 62, that you need to focus on REM, because usually REM isn't a test that we focus on. But yeah, to summarize, I just don't see it being salvageable given the current cost test results. And I don't see it being wise to give it a free pass and approve it on the hopes that maybe future results will show that it might be cost effective from the UCT, because as we said, it still fails the TRC and the RIM.
Your testimony in other dockets was brought up during cross-examination, and obviously the commission made a decision in IRP cases, avoided cost cases, solar choice cases. I mean, do you think it's possible, you know, and I ask this, you know, believing in accountability and ownership, do you think it's possible that the commission maybe sent the wrong signals? Because I'm just trying to reconcile how do we get this far with a program like this, and there's just such strong opposition. Fair, and it's all fair. I'm not saying anything is unreasonable about your position, but it just seems that when you look at the level of intelligence and the hard work and the advocacy that I've seen these parties demonstrate, it's hard for me to see us getting this far and being this far apart, the parties being this far apart.
Sure. So I think one of the things that can happen is when parties are looking at individual cases in isolation, they may not see the broad picture. And so they may adopt something that makes sense for that particular proceeding, for that particular docket, and allow in wording that then causes problems in the future. You know, like for example, this whole idea that all that matters is the impact on the utility system rather than sort of impact at the customer level, which is, you know, the way we always think about our energy efficiency. You know, it's not clear if that was an intentional sort of insertion or that was put in for some other reason, but it's almost like all these sort of things came together to allow the solar industry to push forward with this testimony, well, solar industry and Duke under the MOU to push forward with this proposal here. You know, I also wonder how much of this really goes back to the solar choice metering tariff docket and that MOU, where the solar interest and Duke were, you know, negotiating on the solar choice metering proposal, and you know how much, you know, this was viewed as a way to, you know, affect things.
Mr. Chairman.
Hi.
Can you hear me?
Okay, Mr. Torini?
Yes, can you hear me, Mr. Chairman?
I can now. I could not before.
I object to Mr. Ori's testimony regarding the intent of parties in prior MOUs and the intent of parties and stakeholders in the legislative process. I think it's speculative. He has established and repeated that he has no direct knowledge of this, and it's therefore inappropriate.
Mr. Chairman, Mr. Ori was responding to your question about whether the commission sent the wrong intent or the right intent. Mr. Ori was discussing MOUs, other matters, filed in commission dockets, orders approved or issued by this commission. I would certainly defer to you. It was your question, Mr. Chairman, but I believe Mr. Ori has the ability to answer the question.
Mr. Chairman, I'm not objecting to your question. I think Mr. Mr. Bateman knows that. I'm objecting to the fact that he strayed way beyond your question. This has nothing to do with commission orders, nothing to do with what's approved. He's testifying about the intent of parties and frankly ascribing to them less than honorable motives. I don't think this sort of ad hominem attack is relevant to these proceedings.
Understood, sir. Your objection is noted. It's overruled. We'll give the testimony whatever weight we think is appropriate. Thank you, sir. Mr. Ori, if you would, please continue.
I'm sorry, I've sort of lost my train of thought a bit about how I believe we've got here. But I think I probably covered sort of all the main points. But please, you know, ask a more detailed question if I think we should delve into some issues in more detail.
I think that's all I have, unless there's more you would like to share.
No, I think I've had the opportunity to express my concerns here as well as in my direct and surrebuttal testimony. And I appreciate the commission's time in hearing both my concerns and ORS's concerns with this program.
All right. Any more questions from the commission? Redirect.
Mr. Chairman, I want to express my sincere gratitude for letting those two exhibits in earlier. I know there was a good bit of discussion about whether that would impact redirect. I looked over it. I don't believe we have any redirect, but I didn't want to say that without expressing my gratitude for your patience in allowing those in. Thank you, Mr. Chairman.
All right. So there's no redirect, and if there's nothing else with this witness, Mr. Ori, you can step down and enjoy the California sun.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman.
And Mr. Hori, you are excused. Ladies and gentlemen, we're in recess until 4:05. Good afternoon, ladies and gentlemen. Welcome back to the Public Service Commission of South Carolina. We're here in dockets number 2021-143E and 2021-144E. Present in the hearing room, we have Commissioners J. Williams, C. Williams, Powers, Belzer, and Thomas. And joining us virtually, we have Commissioner Caston. I see that it is 4:06. My plan is to try to end before the 6 o'clock hour today and come back tomorrow at 1:30. We do have a hearing tomorrow, but hopefully we can conclude that matter by 1:30. That may not happen, but if we see that that won't happen, we'll make the appropriate notifications. So let's be prepared to call it a day at 5:30 today and come back tomorrow at no later than 1:30. All right. No earlier than 1:30, excuse me. Okay. Call your next witness, please.
Thank you, Mr. Chairman. The companies will call to the stand Mr. Timothy Duff.
All right, Mr. Duff, if you would pause and be sworn in by the court reporter.
Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And Mr. Chairman, Mr. Duff has already been tendered in this proceeding as an expert, and I assume that stands?
Yes, sir, it does.
Thank you, Mr. Chairman. Hello, Mr. Duff. Would you please state your name for the record?
Timothy J. Duff.
And by whom are you employed and in what capacity?
Duke Energy Business Services. I'm the general manager of Grid Strategy Enablement.
Did you prepare or cause to be prepared 22 pages of rebuttal testimony that were pre-filed with the commission in these proceedings?
I did.
If I asked you the same questions that were contained within your pre-filed rebuttal testimony this afternoon, would your answers be the same?
Yes.
Mr. Chairman, I would ask that Mr. Duff's pre-filed rebuttal testimony be entered into the record as if given orally from the stand.
Mr. Duff's pre-filed rebuttal testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Duff, did you also prepare or cause to be prepared two exhibits that were attached to your pre-filed rebuttal testimony?
Yes.
Do you have any changes to those exhibits at this time?
Not to my knowledge.
Mr. Chairman, I would ask that Mr. Duff's two pre-filed exhibits that were attached to his rebuttal testimony be entered into the record as the next composite hearing exhibit.
Duff rebuttal exhibits 1 and 2 will be marked as a composite exhibit entered into the record as hearing exhibit 13.
Thank you. Mr. Duff, would you please at this time provide a summary of your pre-filed rebuttal testimony?
Yes, thank you. Good afternoon, Commissioners. Thank you again for the opportunity to be before you. The purpose of my rebuttal testimony is to respond to the direct testimony of ORS witnesses Ori and Morgan. In my rebuttal testimony, I will show that witness Hori's opinion of what should and should not fit under the EES, EE, and DSM programs does not square with the language of South Carolina Code Section 583720. The ultimate purpose of the EE DSM programs is to cost-effectively reduce the demand and the supply. Oh, I'm sorry, I got lost. The ultimate purpose of the EE and DSM programs is to cost-effectively reduce demand, and the statute casts a wide net for cost-effective EE DSM programs. It specifically includes energy supply and end-use technologies and does not limit programs to narrow definitions that turn on where energy savings occur. The Commission recently found in Order Number 2021-569 that all self-consumed generation is equivalent to energy efficiency or demand-side management measures as a decrement to system load. Witness Hori's argument that solar PV is a generation resource and not EE is inconsistent with past ORS support of program incentives associated with topping cycle, combined heat and power, which are often actually combustion turbines, and which is similar to the program proposed in these dockets. Contrary to witness Ori's testimony, the total resource cost test is no longer the determinative test for EE-DSM programs in South Carolina pursuant to the commission-approved settlement the ORS entered into in December 2020. Under the 2020 settlement, the parties agreed that the UCT would serve as the determinative screen in assessing cost effectiveness for program approval. Further, under the settlement, the EE and DSM mechanisms will not be revisited until the year 2026. The transition to the UCT for determining cost effectiveness was approved by the Commission and reaffirmed by the Commission in the IRP proceedings. Further, ORS itself has exclusively relied on the UCT in its review of program cost effectiveness in recent EE-DSM rider proceedings. The Commission should not permit witness Hori to propose using a different cost test just to support his opposition to the program. As explained in my rebuttal testimony, even if the Commission had not approved the transition to the utility cost test as the determinative cost effectiveness test, the UCT would still be the most useful test in these proceedings. The UCT's fundamental benefits is that it evaluates the program costs that could be passed to ratepayers and compares them to the benefits of the avoided costs of implementing the program, which directly benefits all customers. Unlike the UCT, a program that passes TRC will not necessarily benefit both participating and non-participating customers. I also explained in my rebuttal testimony that the utility incentives referred to in Mr. Hori's testimony are explicitly required by the EE-DSM statute and authorized by the December 2020 settlement between the ORS and the companies. The company's performance incentive is a small portion, only 10.6% of the net benefits to the utility system calculated under the UCT. Such incentive motivates companies to maximize energy and peak capacity savings for customers while minimizing the costs incurred to achieve those savings. An additional significant error in witness Ori's free ridership calculation, which is based on a totally inapplicable baseline, rendering the calculation incorrect and uninformative. He bases his free ridership calculation on forecasted solar installations for DEC customers on rate RS. This is fundamentally flawed because the program for DEC will not even be available to customers on rate RS. Witness Hori's free ridership estimate is significantly overstated. The participant cost test score, even when considering the federal and state tax credit, suggests that the economics for adopting solar simply don't work for customers. Witness Hori is incorrect that low free rider values are not applicable to solar PV is a well-established technology. In South Carolina, the actual customer adoption rate in 2020 was 0.23%, or an adoption rate of 0.0023. While solar PV has, quote, been around for decades, end quote, it is not being considered for adoption by most South Carolina customers, and in its adoption rate in this state is incredibly low, making a 10% appropriate figure for free ridership correct. My rebuttal testimony also addresses witness Morgan's improper focus on only the cost of the program and his failure to acknowledge the program benefits. I show that his perspective misconstrues how EE and DSM programs operate, which is by reducing certain electricity production capacity and T&D costs that are reflected in a reduction of base rates and other cost recovery provisions. Finally, I show that witness Morgan misses the point of cost-effective EE-DSM program when he asserts the company's solar programs are, quote, sufficient and adequate, end quote. The intent of the cost-effective EE-DSM programs is to incentivize customer adoption of measures. Doing so reduces the cost for all utility system customers rather than being satisfied with what may be sufficient or adequate. In conclusion, the programs proposed by the companies fit squarely under the EE-DSM statute and mechanism recently approved by the Commission. The programs consist of a package of requirements and features that will work together to cost-effectively reduce demand. Because the reduced demand will result in cost savings for all customers, the program should be approved. This concludes my testimony summary.
Thank you, Mr. Duff. If you'll please answer any questions of council or the commission at this time.
Self-described clean energy interveners.
Yes, thank you, Mr. Chairman. This is Emma Clancy on behalf of the Clean Energy Interveners, and I do have a few questions for you, Mr. Duff. Can only see myself now, but I think I'll see you shortly. Good afternoon. Can you hear me all right, Mr. Duff?
Yes, Ms. Clancy, good afternoon.
Great. So there's been a lot of discussion characterizing this program as different from the company's existing programs. Do the companies have any other approved programs designed to reduce energy consumption from the grid in a similar manner as the Smart Saver Solar?
Yes, as I talk about in my rebuttal testimony, the company does have the Smart Saver performance program for non-residential customers, which actually incentivizes topping cycle CHP, which features customer generators that then also have a waste heat capture component. But as approved by the commission, that program explicitly recognizes the whole topping cycle CHP system, which includes generation, and frankly is very consistent with one of the examples Mr. Ori referenced in his testimony.
And did ORS oppose that program?
No, they did not.
Now, there's been a lot of discussion today about the solar water heating program. Are you familiar with that program? I believe you touched on it.
Yes, I did.
Yes. Is there, if you set aside the solar energy component of those heaters, is there any technology in a solar hot water heater that heats water more efficiently than a regular water heater?
No, there's not, Ms. Clancy. The fact is as was pointed out, the sun's energy is used to heat water and then reduce the amount that the traditional electric water heater needs to heat the water temperature-wise. It's a conversion of thermal energy, but it is still you're still using energy to heat water.
Thank you. Now, moving on to the free rider issue, Witness Hori has critiqued the company's free ridership estimates. Could you just briefly summarize how Duke verifies the free rider assumptions in its EM&V process?
So the free ridership will be done as part of the net to gross analysis, which is something that actually was not fully explained by Witness Hori in his testimony, because the net to gross analysis actually contains more than free ridership, and was something that was neglected by Mr. Hori's testimony. But nonetheless, the net to gross analysis will likely be done, and again, I'm not the independent third party who the company will contract to do so, and that's an important point. The company will work to get a industry accepted third party to do measurement verification, but I do believe Witness Hori is correct that it likely will be done by some sort of survey mechanism, because free ridership is essentially the measure of program participants who would have participated without receiving the program incentive. And that's the fundamental flaw with Witness Hori's analysis, is he's looking at customers that aren't even eligible to participate and trying to say their forecasted adoption is somehow representative of customers that participated in the program that would have otherwise absent the incentive. And that is flawed, because if you're looking at non-participants, actually, Ms. Clancy, that's what we would look at for spillover, which is designed to look at the program's impact on non-participants, which would be, as Witness Hori talked about, looking across the street and seeing that a customer may have adopted solar PV on their roof and through program participation, and then saying, hey, I think I want to do that because of it. And that would be captured in spillover and actually increase the benefits associated with the program. Again, the company did not assume any spillover in its analysis because it was trying to be conservative, because again, it does recognize that this program comes with costs, but the analysis was conservative as opposed to Witness Ori's analysis, which consistently didn't look for any additional benefits, but only focused on what were actually, what I would, to use his term, flawed assumptions in how you would estimate free ridership.
Okay, thank you. So I think I heard you say this, but does the EM&V process verify net savings, as in the energy savings actually caused by the program?
So it will measure, the EM&V will do two things. It will measure gross, and then there will be a formal accepted measurement of the net to gross, which will include free ridership. And as Witness Ori said, it likely would be done through a survey mechanism. But yes, it will be actually measured, and it will be presented as part of one of the annual true-up proceedings that will determine what the appropriate savings to claim associated with the benefits of the program.
Okay, so does that mean that Duke will recover net lost revenues only if it's shown through that process that these programs caused an additional increment of energy savings that would not have otherwise occurred?
The company, in part of its annual reconciliation of its programs, just like any other program, will apply the updated results of the EM&V report, which would include net to gross. That's correct.
Okay. And in the case of solar, so then in the case of solar as EE specifically, will EM&V ensure that the companies recover only those net loss revenues that are tied to energy reductions that are distinct from and additional to any energy reductions that would have happened otherwise under the solar choice tariffs alone?
Yes, it will isolate what is deemed to be the measured and verified energy savings associated with customers that have participated in the program only.
Thank you. And is it correct that those net loss revenues may only be recovered for the first 36 months or 3 years after the installation of the measure?
So just with all energy efficiency programs, this program's net lost revenues would be eligible to be recovered for up to 36 months or unless a rate case occurred. If a rate case occurs, then the company's net income is no longer harmed and hence would be adjusted, and so you would no longer need to collect lost revenues.
Thank you. And is it typical to argue, as ORS does here, that a program that is projected to be cost effective should be rejected before implementation or undergoing EM&V?
No, I would say that that's not the case. Generally, we bring what are screened to be cost-effective programs forward. As was discussed yesterday, we take a lot of pride in the collaborative because we want to get stakeholders' input into the program design before it's filed so we can avoid potential concerns about the cost effectiveness analysis. But generally, no, when a program has been cost effective and been applied for in front of the commission, I have not, in my knowledge, been aware of any case where the ORS has opposed an energy efficiency or demand response program that was deemed to be cost effective under the primary screen of the mechanism at the time.
Great, thank you. And now I just have a few questions following up on some of your helpful explanations about shareholder incentives. Can you explain how shareholder incentives encourage the companies to design cost-effective and efficient programs?
Yes. So as was discussed in my summary, the shareholder incentive is a shared savings, is what it's described as, or in the mechanism as a portfolio performance incentive. It is designed on the company being able to share 10.6% of the net benefit, which means the utility system benefits that will be realized by customers, less the costs associated with getting them that will be borne by utility system customers. I think that it's really important that we emphasize that, because energy efficiency programs, utility is only providing incentives because of the reduction in demand on the utility system. If it's not reducing the utility system's demand and energy needs, then it's not reducing the system costs, which would not then justify the cost that would be borne by the utility system. So I think it's really important, to your point, that we look at that this incentive is based off of the utility system costs that will be borne by all utility system customers. And it's 10.6%. So, to your earlier point, why does that motivate us to do it cost effectively? Because if we reduce the costs that will be borne by customers to achieve those benefits, then that 10.6% will be of a greater utility system benefit. Our percentage doesn't change. It's still just 10.6%, but the benefit that all customers are realizing is maximized and larger.
Right, thank you. And do these incentives also help, in addition to encouraging cost-effective programs, do these incentives help make the company's investment in energy efficiency and DSM programs at least as financially attractive as construction of new generating facilities?
So that is the design of them under the South Carolina statute. Again, the incentive is designed to give us a 10.6 of that net benefit. It's going to change by program. Some programs are more cost effective, some programs are less. That's why we kind of looked at it as a portfolio level. And the design of it is, to your point, is really to say, otherwise the utility would have been investing in the supply side resources and earning a return. So by getting the opportunity to get a shared savings, the utility should get a return that is approximate or more than what it would get had it made the supply side investments.
Okay, so just to clarify, in the absence of an EEDSM incentive like the one we've been discussing, could utilities receive a return for, say, building a new power plant, but not for investing in an EEDSM program that actually reduces energy consumption?
Again, I won't say my expertise is rate making, but my general understanding is that yes, we're allowed to earn a allowed return, or an ROR, on our rate base, which is essentially the net book value of invested capital.
Great. Thank you so much, Mr. Duff.
Yes.
Solar Energy Industries Association.
Thank you, Mr. Chairman. We have no cross for this witness.
Office of Regulatory Staff.
Yes, sir. Thank you, Mr. Chairman.
Before you start, can I just ask, am I too loud? I feel like I'm really loud, but I want to make, I'm just asking really for the court's sake, because I feel like I'm really loud right now.
Not for us.
Okay.
I appreciate your enthusiasm.
Thanks.
Good afternoon, Mr. Duff.
Good afternoon.
I'd like to talk with you about the BYOT side of the program real quick. So your rebuttal testimony on page 6 says that the demand response component of the program requires participation in the company's Bring Your Own Thermostat program. Is that right? It's line 16, if it's helpful.
Yes, but it specifies the winter BYOT program. I just want to make sure that you got in the full context.
Okay, thank you. And so if a customer meets all the requirements for signing up for the proposed program, they've enrolled in BYOT, they've installed their panels through a qualified installer. They've checked all the boxes and received the incentive. I do apologize for all of that background. If the customer then unenrolls from the BYOT program, the customer must pay back $200 for each year of the 25-year contract period that the customer is not enrolled, not to exceed the customer's initial incentive payment amount. Is that correct?
That's correct.
Okay, so I think what that means, Mr. Duff, is that if a customer unenrolls from BYOT after receiving the incentive, that the customer effectively receives an interest-free loan to support their rooftop solar installation. Is that correct?
I would not categorize it as that in any way.
Okay. They do receive the incentive up front, correct?
They receive the incentive upon the time they meet the eligibility requirements and have installed the rooftop solar, yes.
Okay. And if they unenroll, they then pay back that incentive over time, $200 per year, until the total amount of the incentive is returned. Is that correct?
That would be how it would work, yes.
Okay, thank you. Mr. Duff, you attended the November 2020 collaborative meeting, is that correct?
Yes.
You participated in the discussion on solar as EE in that meeting, is that correct?
That's correct.
Okay. In that meeting, Duke discussed solar as EE as an incentive to replace the one-to-one net metering rate provided under Act 236. Is that correct?
I didn't describe it as that. I don't recall that direct description, but subject to check of any sort of documents, it may have been discussed that way, but I didn't discuss it in that manner.
Okay. Well, yeah, and Mr. Duff, I guess just do you have hearing exhibit 4 in front of you, which is I think it was originally labeled as Morgan Cross Exhibit number 2.
I don't have it in front of me.
Okay. Sure.
Mr. Chairman, may I approach the Elmo?
You can. I don't know if it's operational. Is the Elmo operational? It is not operational.
Sure. Okay. You know, okay. You know what? I think it's okay. Mr. Duff has accepted that characterization subject to check, and so I'll just say then, Mr. Duff, if you were to look at those meeting minutes, it would be page 5 of Cross Exhibit 4. Do you think that would be where that characterization might be?
If you could read me what the meeting minutes said, I'll be glad to.
Sure. Okay. Oh, I'm sorry. Let me give you a copy.
Okay, that'd be great. Thank you.
Here you go. Yeah. Do apologize for that, Mr. Duff. Okay, so the heading is Solar as EE. It's the third bullet where it says Linda Schaefer. EE incentives are used to encourage customers to buy and use equipment that is efficient so that the company doesn't have to generate as much electricity. Solar EE is the same as any other EE incentive, except the incentive is structured to align with the way solar arrays are designed, so the vocabulary is different. Tim was talking about this concept years ago, but there was an incentive in place at the time that made this unnecessary. Now that incentive is winding down and another one is needed. Did I read that portion of the bullet correctly?
Yeah, you read that correctly.
And then the next part says Shelley Robbins, and do you know Shelley Robbins is on the front page as an attendee. It says that she works for Upstate Forever. Are you
I'm
familiar
not sure
with
she's
that?
still with Upstate, but at the time, I believe she was, yes.
Okay, and the next part of that bullet on page 5 says Shelley Robbins, the one-to-one net metering rate is expiring soon.
Mr. Chairman, I have a hearsay objection. Council is proffering this information for the truth of the matter asserted.
I don't think that it needs to be taken for the truth of the matter asserted. Even taking it that way, it's already, this document is already in the record, Mr. Chairman.
It's an evidentiary objection. I mean, the record is in the record, but the actual substance, I mean, Ms. Schaefer is not on the stand to be cross-examined as to the truth of the matter.
I think the question, counsel, is why are you offering the evidence?
So I guess I would offer it for, I think it is proper to offer it for the truth of the matter asserted. This is a business record of the company. It is quoting an employee of the company. I think it would also be proper to consider it just for the purpose of these concepts were in the air, to show that the participants of the meeting were on notice of discussion of these concepts.
Mr. Chairman, it might be the form of the question, and Mr. Duff can talk about his view of one-to-one net metering, et cetera, but to cherry pick a particular sentence from minutes when Ms. Schaefer's not on the stand, that's just plain hearsay.
Well,
and it's a statement against interest.
It's a statement against interest. Wow. Okay. If you truly are offering that for the truth of the matter asserted, that is without a hearsay exception. It is by definition hearsay. So, is the exception is a statement against interest or a business? Help me out here. I'm trying to.
First, I would say that it's a business record.
Okay.
And it's in the record.
Okay. I'm going to sustain the objection.
Okay. Well, Mr. Duff, I think we can just agree that the meeting minutes reflect what the meeting minutes reflect, correct?
You know, again, they're not quotes. It's kind of a summary minutes. So it's hard to say. I would say that I struggle with it. If you taking the interpretation, because this program is only eligible to a portion of customers who can net meter. So and I'm not a net metering expert, but I know that. And so I don't see how it could be, as you said, a replacement. So I struggle with your characterization.
Thank you, Mr. Duff.
Commissioner questions?
Sure.
Commissioner Caston?
Good afternoon, Mr. Duff.
Good afternoon, Commissioner Caston.
Relative to cost effectiveness tests, is it your opinion that the commission does not have the authority or the flexibility to multiple cost effective tests for evaluating this and other programs?
Commissioner Caston, no. In fact, we always perform the analysis under 4 tests. However, when you look at all 4 tests, what has been agreed upon and approved by the commission is that when making the decision, the UCT test is the primary test. I actually really struggled with witness Ori's testimony saying that we were saying it was the only test, because we're not. And I even provided the test results consistent with how we said you would look at it when you combine the BYOT and the program, which is how the customer and the system will benefit. And when you look at it under those lenses, it passes all of the tests. So I'll refer to my rebuttal testimony and the table. It's on page 14, where we show DEC South Carolina and DEP South Carolina. You see UCT tests of 2.88 and 2.06, which means the benefits that the utility system will receive are double what the costs that will be incurred for the utility and system. And then when you look at the TRC, Mr. Ori is correct that the DEP South Carolina falls short of the TRC, but DEC passes the TRC. And then on the rim test, and this is something that, again, was very odd to me in witness Ori's testimony, is he talks about a holistic view, but we have other tests, the rim test and the participant test, which look at it and tell you where the costs might be greater than the benefits. And so when you look at the rim tests, which is considered the non-participant test, you'll see that the rim test for DEC South Carolina is 1.31, and for DEP, it's rounded up to 1.0, but a 0.97. For the participant test, you're at a 0.99 and a 1.11. So what this tells you is that there is very little cost shift, if any, across both utilities. And the test that is somewhat troublesome for DEC is the participant, which is why it would look at as being something that the customer's out-of-pocket cost could be viewed as being higher than their direct benefits. But again, this is something that witness Ori ignored. When you look at the TRC, you need to look at non-energy benefits. It specifically says in our approved mechanism that in the TRC, it should consider non-energy benefits as approved by the commission. And witness Ori's testimony pointed to Dominion, South Carolina's use of the TRC, and they, in their approved portfolio, recognized 3 non-energy benefits to justify cost effectiveness. So, to your question, Commissioner Caston, I would say that we are very comfortable looking at all the tests because they provide different perspective. However, the UCT was deemed the primary test, and so that's what we were originally filed with the program to justify its cost effectiveness, and we believe should be the grounds for the commission approving it.
Well, I understand that, but I'm struggling to understand what's the point of the commission having the authority or the flexibility to consider all of those cost effectiveness tests if, as you say, well, we have the authority and flexibility to consider all those tests, but we can only consider the UCT test. Is that what you're saying?
No, Commissioner Caston, you have the right to consider all of the tests. That's why I put it in my rebuttal testimony, so everyone can see the cost effectiveness tests. However, at some point, parties had to recognize that if there are 4 tests that are being considered, one should be viewed as the determinative or primary test. Previously, parties had felt that was the TRC in this state. However, the ORS and all the other parties and the company agreed that the UCT was actually a superior view to be that primary determinative test, and so it was agreed upon. That doesn't mean the commission can't and shouldn't consider those tests, but the primary determinative test, consistent with the approved mechanism that the settling parties put forward and the commission approved, is the UCT test.
But you're not implying that primary means absolute and only, correct?
I have not put that anywhere in my testimony, and I do not believe that, sir.
As I recall from witness Ori's testimony, looking at the various cost effectiveness tests, he did not come to the same conclusions relative to those scores.
So,
is that correct?
Commissioner Caston, witness Ori, his ability to say that it doesn't pass the UCT is based off of a flawed analysis. that tried to look at free ridership. I can tell you, I looked at every single measure that's offered by Duke Energy Carolinas and Duke Energy Progress. The average across every single measure is 18% free ridership. Now, the measures that, and just even more importantly, there was one measure that had high free ridership, and it was the highest free ridership was 62%, I believe. 62%, not 79%, as Witness Ori would put forward as a recommendation based off of flawed analysis. And that measure is a light. The fact of the matter is, as I pointed out in my rebuttal testimony, free ridership measures are generally those measures that don't require the customer to put a lot of out-of-pocket cost out. This program does. It has a very low adoption rate, as I pointed out, of 0.23%, which is, again, even Mr. Witness Ori says that it's mature accepted technologies that have high free ridership. And finally, Witness Ori even tries to say that looking at 2020 as the 0.23% adoption rate was looking at a wrong year because of COVID. But in checking, 2020 actually was our highest year of solar adoption because we believe customers were thinking about trying to save money while they were at home. So there are a number of flaws in his free ridership analysis, which is his basis for saying that the program doesn't pass the UCT.
Okay. I can't recall if it was in this morning's testimony or questioning or yesterday's, but talking about the, I guess, participation and collaboration. What parties were present during the collaborative meetings?
Well, I can list them. It's pretty long and lengthy. There's about, I don't know, probably 50 names on this. I can name some. There's the North Carolina Building Performance Center, the Carolina Utility Customers Association, which is a group that represents non-residential customers, the South Carolina Community Action Partnership, which I believe is a low-income group, the North Carolina Sustainable Energy Association, North Carolina Justice, Coastal Conservation League, the Office of Regulatory Staff, and a number of representatives from the company. I can go on, there's more, but I think that's a pretty good list.
Okay, but I guess I was looking at your Exhibit 2, which I think is and I guess I'm just confused on that. Let me see what. I think it's the application for Duke Energy Progress LLC. Exhibit 2, that paragraph 4 on page 3. It says the program, excuse me, is the result of collaboration with the Southern Environmental Law Center on behalf of South Carolina Coastal Conservation League, Southern Alliance for Clean Energy and Upstate Forever, and the North Carolina Sustainable Energy Sunrun Inc., Vote Solar and Solar Energy Industries Association. Are we talking about two different collaborative meetings, groups?
So I don't have the document that you're referencing in front of me. I don't believe it was an exhibit to my testimony.
Mr. Chairman, I have that. Permission to provide this to Mr. Duff.
Go right ahead.
This is direct testimony of Timothy.
I'm sorry, I only brought my rebuttal testimony up. And that's what I was saying is I only had my rebuttal, so I wasn't sure.
Okay. Right.
So the program is the result. So as I mentioned in the discussion yesterday, how the incentive amount was worked out was developed based off of the company providing a range of what could be cost-effective incentives, and then some parties worked together to kind of agree upon that cent per watt incentive. However, there were two collaboratives because then the program design was brought to the other stakeholders in the larger collaborative. It just so happens that many of those members that you read off that were referenced in the application, those are also members of the collaborative. But at that time, ORS, as well as, the Carolina utilities or utility users, the Upstate Forever, those groups are also in the collaborative. So it is a much broader group than the parties that were talked about in terms of how the original incentive amount was developed. But there was still opportunity and feedback sought. The whole purpose of the collaborative is to get feedback from interested stakeholders so that we're designing it and making sure that they're comfortable with the assumptions that we're going to put forward in a filing, because obviously a lot of stakeholders have a lot of input that can be valuable in informing the company on how to make this program effective in delivering the desired reduction in consumption from the utility system.
I could not agree more. What I'm trying to get to, what I'm trying to understand, and I'm confused, and that's probably my fault, no one else is, but I'm trying to understand the timeline, exactly what the collaborative group is, who's in it, that list of over 50, the list that I gave you. I'm not following that at all.
So maybe I can help clear it up. So there was a group of parties that you listed off that were shown in the attachment to my direct testimony that helped determine what the appropriate initial amount of incentive that was put forward in the program design. Those are listed in that document. And that was done prior to bringing it to our Energy Efficiency and DSM Collaborative, which meets every other month with this larger, more diverse group that the ORS participates in. And that group is then used to check the actual program once it's put together and put forward. So that's where we try and get feedback from all these interested stakeholders who are concerned about energy efficiency, and they bring their own perspectives. As I said, the Carolina Utilities Customer Association represents large industrial customer users. And so they're interested in programs that are pertinent to them, as well as pertinent programs in general, because this group is focused on making the company's energy efficiency programs as effective as possible. And so by getting their input, what we try and do is make sure the designs are consistent with stakeholder thoughts so that we really can avoid a lot of the disagreements that we're having here today, because we can try and either clarify questions and answer questions, or we can change assumptions if we know that parties have a problem with assumptions. So it's really designed to hopefully streamline the approval process of programs, as well as, most fundamentally, to use stakeholders as a forum for input to make our programs as effective as possible. And that's not just for new programs, that's for ongoing programs.
Okay, in that group or small group, before the large group.
Yeah.
Who represented the utility public, commercial, small businesses?
So in the small group, it was the organizations that were listed. So they came from a lot of different perspectives. I would like to think that Duke was representing its customers. Again, because we created a parameter that could be cost effective associated with the reduction from demand and consumption on the energy system associated with this program. That range was then worked out with those interested parties to come up with an initial proposal that was ultimately filed, but was first shared with the collaborative to get input on.
Okay. Make sure I understand this. The group in the small group that represented the using and consuming public was Duke Energy, Southern Environmental Law Center, South Carolina Push Conservation League, Southern Alliance Clean Energy, Upstate Forever, North Carolina Sustainable Energy Association, Sunrun Inc., Vote Solar, and Solar Energy Industries Association. Is that what you said?
So those were the groups that were part of helping to determine that initial incentive amount that was used to then put a program filing an application together. However, as I said, that amount was put together initially and we recognized it in the application, but then that group was taken in front of the collaborative where the ORS had an opportunity to talk about those program assumptions, as well as give input into if they even disagreed that it was a program. We did not get that input.
So would it not have still made more sense for those other representatives than those that represent the using and consuming public to be involved with coming up with that number also?
So Commissioner Caston, I don't think that was required. Again, we came up with a program design based off of the input of a smaller group, but that design, which included what was agreed upon with the smaller group, was then brought forward to a group that had the ORS who is directly charged with representing the consuming and using public.
Okay. Was the MOU reached before the cost effectiveness test was performed?
The MOU was, I need to get a little clarification. We performed a range that could be cost effective. So a range of how much you could incent per watt based off of what we knew avoided costs would be based off of the reduction. So that range was used to guide the discussion. That range was provided prior to the MOU. The modeling of cost effectiveness of the program came after, once that amount was agreed to in the smaller group and then taken forward to the collaborative, because we had to talk about the program and the application that would be filed, again giving all the parties, including the ORS at the collaborative, an opportunity to comment at that time.
I understand. What concerns me is that it seems like a significant piece of this pie had already been sliced before ORS represents the consuming public or anyone else. A goodly portion of that had been done, and that's a little troubling.
So, Commissioner, I don't want to disagree that the initial amount was kind of agreed to prior to going to the collaborative, because it was. However, the initial amount that was put forward had to be cost effective. And frankly, looking at a lot of those parties that were in that proceeding, again, I wasn't even part of the discussion, sir, but those parties are knowledgeable about solar and what kind of incentive might be necessary to get a customer to adopt solar. And so, honestly, I don't see anything that would be out of the ordinary of looking at some sort of industry experts to give you a guidance on what kind of incentive would be meaningful, yet still cost effective. Because as I said, we provided a range of what could be cost effective. And then there was discussions that went on with those parties and the company to try and figure out what a meaningful, cost effective incentive would be. Then that was taken forward to get input from the broader group in the EE and DSM collaborative multiple times. And again, if people would come back and say 36 cents is too low, 36 cents is too high, that's something that would have been discussed. That was not brought up. It was not discussed. In fact, it was never questioned whether it would be cost effectiveness. It would meet the cost effectiveness tests, because we knew going in that we looked at the benefits to try and come up with that range. So again, I don't think there was anything at all that should be troubling about that. You want people that understand what would make the incentive be effective to be involved in the process of coming up with that initial incentive amount.
Okay. Well, clearly, ORS does not concur with, I guess, a good deal of what Duke has developed in this program. So, and their role is, I think they define as part of looking after the using it to the public. And I'm not saying that all parties should be looked at and treated equally and fairly. I agree with that. But if you can't see why I'm a little bit troubled, that's kind of troubling, because there's a lot on the table here, and I understand what you're saying and what's been said, but
Commissioner, I think I was going to say I think that a lot of the concern could have been addressed. I think that I struggle as being the person who brings programs forward for regulatory approval in Duke's different jurisdictions, to see this as being some opening a Pandora box. Because as was gone over yesterday when Commissioner Belzer was talking about the tariff associated with the non-residential Smart Saver prescriptive program, that program has a tariff. That tariff applies to that program. And Commissioner Belzer was making that point. Why are we looking at a non-residential program tariff and talking about eligibility of a different residential program, which had a tariff filed with it? Every single tariff and program that we file gets a chance for the commission to weigh in on it and decide whether it works, whether it's cost effective, whether it meets the statutory definition, not a generic EIA definition, but the South Carolina statutory definition, whether it was modeled consistent with the mechanism. And that's what the company did in this case. And if it brings forward another program, the commission will have that same opportunity. This isn't a carte blanche, you can do anything you want. This is a specific program that has a number of requirements with it. A customer committing to have their heat controlled for 25 years in order to get this incentive is no small request. These customers also have to be in the solar choice, which means they're going to be on TOU and CPP rates. So there's a number of things that the customer has to do in addition to making a financial outlay to decide to buy these solar PV panels and install them. And again, the company is looking at it from the utilities perspective because that's what the law tells us to do.
So, since you brought that up, I've had that question and I haven't gotten my head around it. Why, with the existing solar PV 20-year, the commission approved 20-year life, why was it not proposed 20-year as exists?
So as I said the other day, the company looked at this truly as an energy efficiency program. Just as the case with any other energy efficiency program, we look at what the manufacturer's warranty or stated life for the program is. So for an LED bulb, you look at what they say the hours of use is. That's what we use. The manufacturer says 25 years. That's what we're going to recognize. Now, again, if you come in and 5 years down the road, they're failing, that would get picked up in EM&V. But that is our practice for energy efficiency programs. Additionally, there's a 25-year commitment that they're making to have the winter BYOT in their home and controlling their heat during the winter. And if they don't for 25 years, there's a financial penalty to them. So it marries those two together. It's a 25-year commitment. It's not, we didn't look at this as again, net exporter. We're looking at the reduction on the system, which is going to be based off of the manufacturer's suggested life or warranty, which is what we got the 25 years for.
Okay. Honestly, I don't know that I've ever had a thermostat or HVAC system last 25 years. I'd like to. But, so what I'm hearing you say is we need to approve this and see how it works out.
I believe it is in the best interest of Duke Energy Carolina and Duke Energy Progress's customers that the commission approve this program. There are checks in place if this program does not determine to be cost effective. The program will have EM&V done. And I think it's really important to talk about this phrase gamble. I heard gamble a lot yesterday. It's a gamble not to approve it because it projects to be cost effective, meaning it's going to reduce utility system costs more than the cost to do the program. And it's important to note that because of the rider mechanism, the company would not even collect costs associated with 2022 program participation until 2024 because of how the rider timing works.
I'm sorry.
So I guess my point is that the utility incentive, which again, as we talked about, is only a small portion of the utility system investment and is 100% consistent with the DSM statute in South Carolina, the need for an incentive that make the utility whole on a return on their investment similar to what it would had it invested in traditional utility supply side. And then the net income, all of the net income or net loss revenues, which we talked about, which again, that gets adjusted for the actual reduction that's occurring. And Witness Ori talked about the net to gross ratio taking some time. You do need to have a statistically significant sample to do it, but the energy reduction is going to be something that can be measured more quickly than a survey results. So you're going to update if customers are not collecting the same energy benefits, then the program's cost effectiveness will be reduced, and the commission should say, you know what, either change this, which would mean reduce the incentive amount, or eliminate it. And those are the kind of things that we like to see is a ongoing process that tries to improve upon a program. But again, the company's initial assumptions in this program were conservative. I went through and looked at it, and that was the funniest thing in looking at Witness Ori's kind of disagreement about the cost effectiveness. He took a negative view on everything. It was similar to Witness Morgan only focusing on the costs. There was never anything. Witness Ori is clearly an expert, and I want to make it clear, I never questioned his credentials. I think what he has done in California is very impressive. I question his familiarity with South Carolina, and I still do. You know, in his original testimony, he talked about one of the risks of the program would be that if you approve this program, the company could say welding a frying pan on top of a generator would be considered energy efficiency. Well, that is a very simplistic example of CHP. a frying pan on top of an engine using the waste heat to heat the frying pan. That is CHP. In the testimony, I then reminded him of that in our rebuttal testimony. Clearly, he wasn't as familiar with South Carolina. So I'm not questioning his credentials. What I'm saying is he's not as familiar with South Carolina, and he took no opportunity to find potential additional benefits. Everything was on the very aggressive side, where I can point to numerous things the company did that actually was conservative, because again, we don't want to overestimate the benefit and then have to true it up. Because one of the things that also is important to note in the rider, Commissioner, is that if we over collect from customers, meaning we project too much participation, or we don't get the savings that are out there, and so our incentive amount and net loss revenues have to come down, we pay that back with interest. So the company always tries to be conservative with its assumptions, because it recognizes it's using customer dollars for these programs, but the benefits that are potentially there for customers are greater. And we're confident in that because we were conservative in doing the analysis.
Okay. So if this program is adopted, if it's approved, January 1, 2024, Commission says we don't think it's functions as it's supposed to, eliminate it. What happens to those 25-year contracts and existing solar systems that have been installed?
So that's one characterization I think Witness Ori was correct on. We would not go back and try and reclaim the incentive from the customer or have them tear the panels off. The company would recover those costs and then adjust the energy savings used for the benefits that are used to determine the utility incentive, and that would be reconciled. And then the net loss revenues that would be claimed would also be reconciled for if there are lower energy savings. But again, the company actually believes that the energy benefits will be greater to the utility system. And so we're confident that it will deliver the benefits. But if it didn't, there is a reconciliation approach. And oh, by the way, as I said, because of regulatory lag, the 2022 participant, the cost and those lost revenues that are actually occurred, we wouldn't collect that from customers until 2024. So customers are, in a way, getting the program costs before we would ever collect them from them. So I think there's a number of protections that around the EM&V, how the rider works, the true up of costs, all that really say this is a appropriate new program for the commission to approve, because it will deliver cost-effective reduction in consumption and demand on the utility system from a program that is clearly consistent with the South Carolina statute for demand response and energy efficiency programs. It clearly meets the definition of demand-side management activity.
Thank you, Mr. Duff. I appreciate it. No more questions, Mr. Chairman.
Mr. Chairman.
Vice Chair Belzer.
Thank you. Good afternoon, Mr. Duff.
Good afternoon.
There's a lot right now that I'm trying to figure out where to start with, but I want to piggyback off of your conversation just now with Commissioner Caston. And let's talk about this mechanism. Is it correct that annually Duke files an application to review the cost that's associated with the DSM EE rider, and either sometimes there's a decrease in that rider and sometimes there's an increase?
That is correct.
Okay. And so any cost associated with this proposed program, should it be approved, and that's a should, not a will, okay, right. That's a should, would be looked at in that annual application and put forth to the commission. I think ORS usually files a nice report, nice cover, looks very professional on that application. Is that correct?
That is correct.
And we don't always go to hearing on that. A lot of times that's done by a paper proceeding. Is that correct?
That's correct.
Okay. But at that time, the utility puts forth various measures such as the UTC and other tests showing cost effectiveness of the program during the period under review for that year's application.
That is correct.
Okay. So should this be approved and should it come up for review, that would come up annually, and the commission would be advised whether or not the cost test or the results of the cost test. Is that correct?
That is correct.
Okay. And it's not just this, it's all of the DSM and EE programs that are currently available or offered under Duke's, DEX, and DEPS tariffs. Is that correct?
That is correct.
Okay. And when we talk about the revised mechanism, that the settlement agreement, I think from 2020, that was an application, and I don't know if you have the order that's been referenced here. I think we've talked about 2021-32 and 2021-33.
I don't have the orders,
Okay.
but I'm fairly familiar with them.
Well, would you accept, subject to check, that the application for that revised mechanism was filed on June 26, 2020 in the DEC case, and it's probably the same date for DEP.
Yes, subject to check.
I just happen to have the DEC order.
I'm trusting you then. I don't think I need to check.
But that was filed on June 26th of
That sounds right.
2020. And the order approving the approved mechanism was filed with the commission or by the commission January 15th, 2021. Does that sound correct?
I believe that's correct.
And there was a settlement agreement with the parties to that docket. Is that right?
That's correct.
And that settlement agreement was signed somewhere around December 4th, and it was filed with the commission on or about December 4th.
That's correct.
Okay. There are various signatory pages, so there might have been different dates of signatures. And that settlement agreement, as part of the settlement agreement, included the application that was filed in June of 2020.
Subject to check, yes.
Okay. And we've had reference from that mechanism a number of times to the language regarding the UTC. Okay. Now, in your testimony and in your summary, you've indicated that under the settlement agreement, which was approved by commission order, that the UTC would serve as the determinative screen. Tell me what you mean by determinative.
So again, as I answered to Commissioner Caston, we believe the commission should look at all the tests. That's why they're provided in the annual rider filing. But when determining whether a program should be offered, if you're looking at all the different perspectives that are given by the different tests, we agreed with the other parties that the primary or determinative test, the one that would kind of break the tie, would be the UCT.
Okay, so when you say break the tie, that doesn't mean that that is the only test that is being looked at.
No, it does not.
Okay, I just want to be clear on that. Now, let's look back in time. So this application for the revised mechanism was filed in June, and at some point, the parties to that docket were discussing the revised mechanism. Got to a point where they reached a settlement. It was filed in December, and yet we've got minutes from a EEDSM collaborative from November 2020. And at that point, at least by that point, probably a good bit before, Duke already was considering some sort of programs such as we have before us today. Is that correct?
That's correct.
Okay. And that was in November or before 2020. And at that point, Duke knew that solar choice tariff was going to have to be decided before May 30th, 2021, right?
Not as much of an expert on that, but subject to check.
Okay,
yes.
subject to check that the solar choice tariff, the statute said for participants after May 30th of 2021. So
that sounds correct. Yeah.
Had to be decided by then. Was the commission in all these dockets ever made aware of a possible EE filing, combining? Because I think Bring Your Own Thermostat was filed somewhere in the fall of last year, and probably decided at the end of the year or the first part of this year. Does that sound right?
Well, there is a clarification on that, Commissioner.
Okay.
So the summer BYOT was actually approved a number of years ago.
Okay.
But
Winter.
we moved to winter last year as it was decided that we were now winter peaking.
Okay. So that was filed sometime the end of fall of last year, and probably
Yeah.
decided toward the end of the year or first part of this year.
That timing sounds approximately correct.
Has
Yes.
there been any discussion or any indication to the commission that, if you know, you may not know, that Duke was considering trying to roll something innovative such as had been put forth here?
So I don't believe there was any communication with the commission on that, but I don't know because, again, I really was not involved
That's
in
fine.
the solar choice proceeding.
I don't know all the layers and who all's involved, and if you don't know, that's fine. Okay. I just am questioning just because there has been a lot going on. Y'all have been busy. ORS has been busy. The interveners have been busy. The commission's been busy. We've just had a lot of solar going on over the last 2.5 years, and it's really tough to keep up sometimes, but that's the way it goes. Now, let me see. I did have another thing. I think Commissioner Caston covered some of my other questions, so I appreciate your attention this afternoon. Thank you very much.
Thank you.
All right, we're in recess until tomorrow.
But can I ask something, if I may? I imagine we're going to finish tomorrow, and I have an issue that I would appreciate the attorneys addressing in their closing statements, because I think we've already had that request, and it's a legal argument.
Right, so I have no expectation about whether or not we're going to finish tomorrow, but if we do.
Well, I think they may need a little time to prepare and not necessarily on the fly.
Oh, absolutely.
So,
Go ahead.
so I would ask the parties. There's been a lot of discussion and testimony regarding 58-40-20I, and what I would like, and some of y'all that have worked with me, both from the commission staff and from the companies and at ORS, you know, I think I may have an answer, but then I started questioning something again. What I'd like to know about that section in particular is that that's the section that references the settlement in the Act 236, that order 2015-194, and that section specifically references that order, and for customer talks about the program costs for customer generators applying before June 1, 2021, and that recovery from the recovery of cost under 2015-124 remains in place until realized. And then we get to the sentence about electrical utilities are prohibited from recovering lost revenues associated with customer generators who apply for customer generator programs on or after June 1, 2021. My question is this. That last sentence, is that applicable to the cost recovery and incentive mechanisms that were provided for in 2015, in Order 2015-194? Because my recollection is that order required one-to-one payment of excess generation, and also had the incentive mechanism of lost revenues, and that's where I'm trying to reconcile here. Does that make sense what I'm asking, Mr. Bateman? You look...
Commissioner Mesa, may I? So just to repeat, make sure I understand. Your question is, does that final sentence, which is the sentence that I think much argument has been had over, does that final sentence apply to cost recovery for the DER programs going forward? Is that?
No, sir. Does that final sentence, is that referring to the cost recovery mechanisms and the incentive payment that was provided for in Order 2015-194. Does that make sense?
Exclusively or okay. Okay.
Yes.
All unclear, Vice Chairman. Thank you.
Okay. Anybody on the World Wide Web want to weigh in? Okay. Thank you. Thank you, Mr. Chairman.
All right, so I'm not going to say it's a pretty big ask, but because it has been asked, there's definitely expectation for it to be well covered. Anticipating that we may finish tomorrow, do the parties have enough time to prepare to make that argument? Because it is 5:30, essentially.
Mr. Chairman, I believe we can, though it may make my closing statement a bit longer than the 5 minutes I'd originally promised.
Well, we asked for it, so.
We can comply with that request, Mr. Chairman. Not a problem.
Okay.
Alternatively, a legal brief is, we'll defer to whatever the commission would prefer.
I'll take both.
Both.
Okay. And so we've heard from ORS, we've heard from the Duke companies, the self-described clean energy interveners.
Yes, Mr. Chairman and Commissioner Belzer, we can include that in our closing statements tomorrow, and/or in a legal brief, whatever the commission would prefer.
Well, she's requested both, and so that's the expectation. Right. Well, obviously, yeah, the brief is not due tomorrow. Solar Energy Industries Association.
We should have no problem with that as well.
All right. And so, how many parties plan to give a closing? Will it be obviously ORS, the Duke companies, the self-described Clean Energy Interveners, and Solar Energy Industry Association?
We'll just have a short closing statement.
Okay.
Mr. Chairman.
So that's 4 closing statements. We're looking at, what, about 20 minutes each? Just being honest about it, probably about 20, 25 minutes each.
Mr. Chairman, on behalf of ORS, I doubt our closing statement will be that lengthy. More than 5 minutes and less than 20.
Okay. All right. Are there any questions about the expectations? All right. So the goal is to reconvene tomorrow at 1:30. And if there's nothing else, we are in recess. Yes, Witness Duff, you are still on the stand. You're still on the oath, and you cannot talk about your testimony with anyone. All right.
Thank you, Mr. Chairman.
Everyone good to go? All right, we're in recess.